losses. My lord, I beg to mention item 8, top of the list, my lord. My lord, kindly be taken up next Tuesday, my lord.
Wait,
No, I won't be able to prepare the case yesterday because I was suffering from headache actually.
on the prayer of Miss A. Devi, Learned Counsel for the petitioner, the registry should list this matter again on
Tuesday.
8/9.
Yes, oblige.
May it please, your lordship. Lordship, I pray for listing of a matter in admission column, your lordship. Next week.
May I please, your lordship? Lordship, I beg to mention item number 23 for admission. Kindly adjourn the matter for the day. My
Okay.
senior has some personal difficulties.
A prayer is made on behalf of Ms. S.B. Chaudhary for an adjournment in the matter on the ground of personal inconvenience. Prayer accepted. The registry to list this matter again on 2/3/9. 3/9.
May Lordship, I'm praying for listing of a motion matter tomorrow, Lordship. Matter context to transfer matter, Lordship. It's in violation of Rule 25 of RTF of Lens.
May it please your lordships. With regard to item number 33, lordships, we have filed an IA yesterday for vacating of the interim order dated 13/8/2026. So I'm praying that the IA be listed today
It
along
will
with.
not be possible to be listed today. It will be listed in its normal course. Let the matter which will pass out.
My lords, also we have filed an affidavit in opposition so
Everything will
that,
come together. We'll fix it.
my lords.
May it please your lordship. Lordship, I beg to mention a case relating to contempt of court. Oblige.
And I sincerely apologize for not being present yesterday, Lord. Lord, the IA was filed for,
None appeared.
my lord,
It was kept for time being at your request.
my lord,
But when the matter was called up,
my
none
lord,
had appeared.
my junior was here, but he, at that, no, my lord, he was in
We
court.
had taken up the matter on 10-15 minutes. We waited for you.
He was also in leg, my junior was also in leg in court 19, so
Okay.
when he came, my lord, it was over by now.
Now, what is your solution?
My lord, the case, if your lordship is,
Projection made in the writ petition is totally perverse. It's not what is there on records.
pardon me, lord.
The projection made
My lord,
in the writ petition
my lord,
is on a different tangential matter than what is there actually.
my lord, may I submit?
Now,
I-
tell me first thing. Under the provisions of 12C, a person who is being given a waiver therein, what is he entitled to? What are the benefits he is entitled?
My lord, his benefit to he's entitled for the benefit of having education without paying the fees.
Fees, not
And
the,
that fees can be reimbursed from the government by the school.
Forget it. It's not that he will also be required to be given the transportation waiver charges.
My lord, that is not explicitly said in the act.
Yes, it's not said. So how can you demand for that?
No.
What is not there?
No, my lord, I'm coming. I will answer every question. The case projected by the department, the school is that I have refused to pay the fees for the from class 9 onwards. That is wrong, my lord. I have time and again said, my lord will appreciate this, the father.
Now, first, let us come to the period prior to the waiver. There was no prayer for waiver at that point of time.
My lord, that was made later on, my lord.
No, later on, show me.
My lord, kindly appreciate, my lord, I'll come to the representation made before the district.
Tell me about that prayer. That before the authorities you had gone, and thereafter you had also made a
My lord,
prayer.
kindly see, page 38, annexure 8. This was the representation made before the district authority, who is the chairman of the monitoring committee under the RTA Act.
And the boy is not attending school. Why?
Now, Now, after the summer break, he's going, my lord, as I'm told, my lord. Prior to that, he was not allowed to go. Now he's going. my lord.
Yes, yes. Show me the period.
Now, my lord, kindly may I read this Annexa 8, my lord, just first two paragraphs. That's just coming to the core issue, my lord. I am not claiming any benefit after the class. Page 38 of my petition, my lord, of the writ petition, not the IM. my lord.
24.
I believe Lordship has taken it for disposal, my lord.
Naturally.
Yes. Page 38. Just first paragraph I would like to read. Reason later representation before the chairman come deputy commissioner, district level implementation and monitoring committee for implementation of section 12(1)(c) of the right to education. May I read? No?
This is 24.
Just two paragraphs, if I may read. Just two paragraphs. After that,
Okay, show me the direction of the.
yes, thereafter, my lord, the direction. My lord. Thereafter, my lord, page 43, they were called for the deputy commissioner, additional district commissioner on behalf of the deputy commissioner, called for a meeting at page 43, my lord. This is not required. This is the next order, 44 is the order. May I read, my lord? Both parties are present along with their advocates. Competent officials of Samagra Shiksha Abhijan are also present. It appears from the statement of the complainant that he has never submitted any petition to the school authority for or any government agencies for availing the benefits under the Right to Education Act 2009. The school authority is heard. As there was no petition made by the parents to the school authority, allegation of inaction by the school authority does not arise. However, in order to ensure that child is not deprived of education, after hearing all stakeholders, order is hereby passed that the parties will submit an application to the school authority for benefits under Right to Education Act 2009 within 3 days from the issue of this order. The school authority will take action on the petition submitted by the parents and will resolve the matter based on the eligibility of the student within 7 days of receipt of the application. The Inspector of Schools, Kamrup Metropolitan District shall constantly monitor the process and apprise the undersigned of this development. This order comes into effect immediately. Next portion, next page. From Sri So-and-so, Assam State Commission for Protection of Child Rights Survey, Beltala So-and-so, to Mr. Polas Ranjan, this is the father of the child. Regarding your complaint against SBOA Public School, Gauhati, with reference to your above mentioned subject, this is to inform you that the Assam State Commission for Protection of Child Rights has reviewed the complaint received from you regarding SBOA Public Schools bad attendance of Master Tushar Ranjan Borua. In this regard, the Commission intervened the matter and has obtained the admission list for the academic year 2024-25 under the Right to Education Act 2009. The report highlighted that Master Tushar Ranjan Borua admission to class 8 has been approved.
7.
Sorry, class 7 has been approved. Then, my lord, next page, kindly see. This is a letter from the principal of the SBO Public School. They have claimed reimbursement for 2024-25. See, submission of list of students admitted under the provisions of so-and-so Act, reimbursement of fees under section 12(2) of the RT Act 2009. This is their right. They can do it.
But
Now-
this is for the session 24-25.
24-25. Now, kindly see I'm not going into anything else, my lord. Kindly see
Come
the
to page
impugn.
47.
Pardon, my lord.
47.
Yes, 47 is this is the payment of transportation fees. My lord. Then, my lord will see next page 48. They held up my admit card and they did not allow me to appear in the exam. See this boy, how he was suffering.
And at the
Then
same time,
after
there is
this-
an allegation
Pardon?
that you had gone to the media. And there was also a order of the
Civil court.
And you had said that this order was forged.
That aspect I have to take instructions.
There, it's there.
Well,
Where
this,
is the applicant?
my lord, this
Right.
aspect is certainly not connected to this matter.
No, we'll have to see your conduct also. Okay, read.
My lord, Release of admit card and permission to Tusharanjan Burua to sit and attend a class 8 examination conducted by SBU Public School. After this letter, they release my admit card. Then I again submitted a application for
No, no.
waiver of,
First and foremost, whether this transportation is also.
my lord, if
involved
required, my lord, we prayed for a waiver, my lord. That doesn't mean that they have to waive. We can definitely pray, my lord. This father of the child is a disabled man. He suffered 4 serious surgeries in his spine. Now he is more than 40% disabled. I have submitted annexed the document to that effect, my lord. If lordship can see this at page 22, my lord. 40% disabled, my lord. Because of spinal injuries and 3 times I have spinal
Come to
surgery.
page 52.
Yes, ma'am. 52 is the impure note. What they are charging for, asking for to pay, my lord. 2022-23,
There was no application.
my lord,
Your end for 22-23.
my lord, they can say there was no application, but they do not, but I do not have any proof that I submitted, my lord.
No, what is not there, that is not there.
My lord,
You
if it,
cannot
even
presume.
if, presume it for a moment, my lord, presuming it for a,
When the waiver was given to you for 24-25 in 2024, where is the action taken on your part that this prospective waiver is not permissible, it should have been retrospective?
my lord, kindly appreciate, my lord. Even if, presume it for a moment, even if there is no application, there is no bar that I cannot make the application now.
Have you made it?
My lord, these are the
Because
applications.
when you went before the authorities.
My lord, these are the
Mr. Counsel, when you went before the authorities, you were only claiming the current waiver. The
My lord,
current
if
waiver.
they want to make me an application
They
right
want
now,
or they don't want to, it's a different question altogether.
my lord, kindly see what is,
If they-
kindly see their conduct also, kindly see their conduct also.
Let us understand. Prior to the financial year 23-24, that is prior to class 7, where is the demand made that I should be covered under 12C? Because your representation is prospective,
Absolutely, madam.
and that too in pursuance to a PIL file in this court. Fine, you are entitled. But we'll also have to see whether the action on the part of the school authorities is not giving it to you is also within the purview of the Act of 2009.
But what I sincerely submit, my lord. See their conduct also. They claim reimbursement, kindly see, 24-25, they claim reimbursement. But again charging from me.
Where?
See page 52,
52. Okay, let us see.
column 3rd, row 3rd, 24-25, class 7.
RT benefit extended covered by the to the extent covered by the approval of law. Right. Fees they are not claiming. You come to the next page, 53.
Yes.
23-24 transport bus charges.
My lord, tuition fee they cannot take, my lord.
They cannot. That they cannot. They are not taking.
My lord,
also.
my respectful submission, we prayed for an waiver of the transportation fees. If they do not waive, my lord, we have to pay. We'll pay it, my lord. And we have,
We will protect you.
my lord,
to
may
the
record my
extent-
submission, my lord.
Mr. Counsel, we will protect you to the extent of the
Fees.
the annual fee which they are charging after the approval was granted by the competent authority. After you had approved the competent authority, whatever benefit under 12C is.
My lord,
You-
kindly, once, my lord, just for a while, my lord, kindly take the representation that I made before them.
After the order.
No, prior to the order. In
Prior to the
2020.
order is waived out. Now they said you have never appeared. You have never applied for waiver.
My lord, that is a disputed question, my lord.
No,
My instructions said
Please-
I applied,
please-
my lord.
Please come to the order at page 44.
That I have seen, my lord. Kindly
Then
come
how
to
can
pay.
we go-
What
how
I
can
said.
You can't breathe hot and cold in this.
No, I am not. I'm aware of that, my lord. Kindly appreciate this application that I made before
Tell
the.
me in page 53, with regard to the areas of fee and transportation charges prior to the approval granted, what is to be done?
My lord, to my to my instructions, my lord. We prayed for a waiver of the fees. That application is there.
No,
Here,
after the order of the.
no, kindly appreciate. I'm coming
We
to,
will not go.
I'm
to-
answering to your lordship's queries.
The competent authority under the act has held that you are not submitted.
My lord, just allow me to complete my submission, my lord. We prayed for a waiver of the transportation fees. If they do not waive, we will pay it, my lord.
Okay.
First
May I,
point, my lord. Second point, that the fees they are asking for, such as annual and sessions fee component, tuition fee component,
For that period, they will not be entitled.
and we have not charged also, my lord.
After the order of 25, 20.
my lord, my respectful
We
submission.
don't
my lord,
require that, my lord.
I faced this. That is why I, time and again, my lord, I am requesting your lordship to read first two paragraphs of the page 38, my lord.
So till which period you are, this entitlement is there? Till which period?
My lord, I am entitled to class 8 up to the age of 14.
Hmm.
From 9 onwards, I am not entitled. I am not asking for even.
Have you paid?
No.
Have you paid?
Well, that
Nine.
instruction I have to take, but I
No,
requested
my
them to
lord,
pay,
no.
my lord.
Para 15, page 15, you say you want installments. We'll give you installments.
My lord.
That's
No issues.
very well, my lord. I'm obliged to this, my lord.
So for the period from 24, 25, that is class
5
7
and
and 8, you are not entitled to pay anything.
No, my lord, what I said,
Including the transportation fee.
my lord, transportation also I will pay. Just allow me some time and installment so that I can pay. One. Two, my lord. Two, my lord, I'm entitled to the fees waiver from class 5 onwards. Kindly, that is why I'm fervently praying.
No, come to page 44.
Well, I'll come to that, my lord. My fervent prayer, my lord, kindly read first two paragraphs at page 38. First two paragraphs, 38
Let
and
us see when it was made. 24.
24, my lord.
So when you make a prayer in 24, why did you make?
That is what I'm, may I read, my lord? May I read? Most respectfully, it is stated that my son, that is Tushar Ranjan Borwa, was admitted in the SBI Public School, Korsuk, Gauhati in class 1, section C, rule number so in the year 2018. Thereafter, while he was studying in class 6, I had to undergo 3 major operations of the spinal cord, which was carried out at Indian Spinal Injury Center, New Delhi. It is stated that I had to incur.
So where did you study in class 6? Which year?
24.
In 2018, he was in class 1.
So
So
which is the year
19
when he was in class 6?
24.
23, 24.
20, 21, 22, 23.
24.
Maybe
my-
23, Mila.
23, 24,
Yes.
Yeah.
right?
Mala.
14-5 session is over, my lord.
So 23, 24 onwards, you project that you had a disability.
Mala.
Before that, you did not have.
I pay, my lord. I will pay. I was just asking them to give some leverage so that I
give you
can.
the maximum leverage, Mr. Counsel.
My lord, appreciate the predicament that these persons are facing, my lord.
We would have proceeded to ask Mr. Brian
My lord.
to waive the total component. We would have, but your conduct does not.
My lord, in my respectful
Impede us
submission,
to do that.
what I respectfully submit, my lord. What I respectfully submit.
And come to the prayer.
Pardon?
Come further to that representation.
Yes, please, yes. Due to the financial constraint, I am unable to pay the school fee for my son. For the
School fee
default
for my
of
son.
payment of school fees for the academic year 23-24,
So
while my son was
from
studying
page
in class
23,
6. Pardon me, lord.
23, 24.
Yes,
Class
from,
6.
from class 6 onwards. my lord. The school
So
has
you want a waiver for 3 years, 6, 7, and 8.
8 million.
And what about the transportation?
Transportation fees, my lord. We prayed for an waiver. If they do not waive, my lord, I don't have any option. I will pay just only my folded hand prayer, my lord.
Now,
If they give some, if this honorable court gives some.
Mr. Dr. Chamua, because of this issues being so raised by the parents, do you know who is the actual victim here?
This is the son, my lord.
Do you know his condition, what his condition would be?
My lord, he has been facing serious problem in his classroom. Everybody, including teachers, my lord. We don't have video clips, but
Yes.
he is making complaint that he has been subjected
See,
to
the
serious
only-
mental
only
torture in the
simple-
school.
With regard to the manner in which the transportation fee that would now be
Required to pay.
required to be paid would be paid, and the fee of class 9 and 10 would be paid.
But he's
Absolutely.
reading in class 9, so 10, my lord.
9 and 10, both.
Yeah.
Your fee, how will you pay? Because you say that you are in a bad shape.
My lord.
Once we get that, we will request Mr. Bhuya again to have a look.
My
When
lord,
can you file that?
My lord, first thing first, he is relying on with regard to a statement made and a certificate. That is of 2020. I have doubt because I have my client, according to my instruction, he is fit and fine, roaming around. Now, before doing the case, he is coming with a support. This kind of thing is going on. So why not a medical?
this
board
kind of submissions,
Mr.
this is not acceptable. No,
Mr.
no, I have a
Chomoha,
reservation.
Mr.
I have to
Chomoha,
express my reservation.
Mr. Chomoha,
Sorry.
Mr.
Sorry, my lord.
Chomoha,
I apologize.
this
I apologize on
this
behalf of
attitude-
Mr. Bhuya, Senior Counsel.
this attitude, please eschew. We are with the boy and we are doing what is.
No, my lord, what kind
permissible
of
for the-
submission is this? That has, my lord, this is
It
it.
is, he is free to make that submission.
No,
You are
my
free to
lord.
make- Yes.
Then I'm also free to express my reservations,
Please,
my lord.
please, we have accepted that. Have we stopped you?
Can
Have
anyone,
we stopped you, Mr.
my lord, what I'm sincerely submitting, can anyone say like this, my lord?
Okay,
Can anyone say like this?
okay,
A person who is facing disabilities, my lord.
okay. Now we ask him to appear before a medical court.
Yes, medical board, my lord. That will suffice, my lord. And if that is so, my lord, I am very grateful to your lordship, my lord, because
We
his
are-
conduct
My
is
lord,
horrible.
what I sincerely
Putting up
submitting,
a
my lord,
medical board in Ames.
Yes.
And
my lord, we are not taking up a case as regard.
Mr. There are many submissions made in this court. It is for this court to accept what is to
Absolutely,
be
my lord.
accepted and what is not to be
My
accepted.
lord,
Have we given credence to that
No,
submission?
no.
Then why are
I'm-
you getting unnecessarily agitated?
I'm
So
not,
now we are requiring the father to be placed before a medical board, which we will constitute.
my lord,
My lord, my lord.
what I sincerely
Which
submit.
will be out of the water, my lord.
But,
I can assure that.
My lord, what I sincerely submit, my lord.
But Mr. A. Bhuya, learned senior counsel, assisted by Mr.
And Sharma, my lord.
N. Sharma, learned counsel for the petition.
My
Also
lord,
heard
before, if
Mr.
lordship is passing an order that the father of this child is not a physically disabled man.
I'm saying there is a dispute, so we want to get.
No, my lord, that is not an issue. What I sincerely submit is, if that is their submission,
You don't want me to go to that extent? Then stop your submission. Let us deal with the boy's life.
yes.
Huh? If you want,
No.
I also have a way out.
Absolutely, my lord.
Heard Mr. Authorised, also heard Dr. A. Chomoha, learned counsel, appearing for the respondent number. Respondent number 1, oblique writ petition. The issue in the present, the interlocutory application has been instituted, praying for vacation, modification or oblique vacation of the directions passed by this court wide order dated 15/6/2026 in WPC number 3123/2026. This court wide they said order had directed that the petitioner hearing be permitted to provisionally be provisionally permitted to attend his classes and continue with his studies until further orders of this court. The said situation had so developed on account of the fact that certain fees payable by the petition on account of the studies pursued by the petitioner in the applicant school was not paid along with the charges towards the transportation facilities availed for the petitioner. Also, although there are contentious issues arising in the connected writ petition, this court is only concerned with the future of the petitioner, who is a minor boy, and to ensure that the petitioner gets a petitioner is permitted to pursue his studies without any distraction. Full stop. This court had requested Mr. A.K. Bhuiyan, learned senior counsel, to grant waiver of the school fee of the petitioner right from class 5 to class 6, for class 5 and class 6. Inasmuch as such waiver has already been granted by the school authorities for class 7 and class 8. Mr. Bhuiyan, learned counsel for the petitioner, has graciously accepted such request of the court,
My lord.
and this court had also granted liberty to the school authorities to approach the competent authority of the government for being reimbursed with the fee for class 5 and class 6 also. Accordingly, the petitioner would now not be required to pay any tuition fee and or any other fee for the purpose of persecuting his studies, right? For having persecuted his studies right from class 5 to class 8. The further claim of the school authorities is for payment of the transportation fee for the year
23, 24, no? 23, 24.
only 1 year.
My lord,
My lord.
page 53, the charges they have shown.
For the year 2025 dash 2022-23, comma 2025-2026.
Yes.
27,600 and 35,690.
The said amount works out to rupees
35.
63,295.
My lord.
The father of the petitioner shall approach the school authorities with an application within 7 days from today, praying for a discount in the transportation charges so charged. The school authorities, on a receipt of such a representation from the petitioner, shall sympathetically consider the same and grant a discount to the maximum extent possible. Full stop. Mr. Chamua, Dr. Chamua, learned counsel for the petitioner, submits that the amount now determined by the school authorities would be paid by the petitioner within a reasonable time. Full stop. As regards the fee to be paid by the petitioner for persecuting his studies in class 9, comma, Mr. Chamua submits that the parents of the petitioner are agreeable to pay the same. However, he prays that the same would be permissible to be paid in installments, right?
My lord.
Full stop. In view of the above development taking place in the matter, comma, this court directs the parent of the petitioner to ensure that the petitioner resumes his classes without fail from tomorrow. Kali date today.
My lord.
The school authorities would extend to the petitioner all due care and attention as being extended to the other students in the said school, and he shall not in any manner be discriminated against. Full stop. The father of the petitioner shall, within a period of 10 days from today, file an affidavit before this court as to the manner in which the transportation charges, as would be now determined by the school authorities, and the fee of the petitioner for class 9 would be paid. So, the said affidavit be filed on or before 9/9/2026. So, Mr. Bhuya shall also advise the school authorities to arrive at a decision with regard to the prayers made by the petitioner before it in terms of the liberty granted herein above for a reduction, for a discount in the transportation charges. Such decision be also
Placed before the court.
communicated to the father of the petitioner by 7/9/2026. Registry to list this matter again on 14/9/2026 for further
Further.
hearing.
Deeply obliged.
My lord,
Bless.
my lord,
My lord, may I pray one thing, my lord?
Like you to be here.
My lord, may I pray one thing, my lord? These court's order should not be interpreted in that manner, going to media and you know,
Sir.
kindly see.
That I ensure.
Either of the parties are barred from raising the issue involved in the present writ petition
Yes,
before the media
absolutely, my lord.
in
That's
any
the gag
either
order.
of the parties.
Yes,
I'm obliged. I'll
my
ensure.
lord, absolutely. I'm deeply obliged, my
You
lord.
don't ensure, we know how.
I'll ensure.
And Mr. Chamua, there would be 101 submissions made in course of a proceeding. Everything need not be retorted to. And if you retort, it becomes a dispute.
My lord,
Then this
one should not hit below the belt, my lord. We also know how to interact, my lord. If somebody hits below the belt, the reply will be like
he
that.
made this submission. I'm giving an opportunity to dispute it. Please dispute.
No, not now. This submission was not necessary at all.
Dispute.
We are learning from Mr. Bhuya.
No.
Is he
Mr.
teaching
what
like
Mr.
this to
Bhuya
us?
Said,
I'm his junior.
what Mr. Bhuya said was not out of context.
No, my lord.
Was not out of context. Let us keep it at that.
My lord.
I'm obliged, my lord. Deeply
Mr.
obliged.
Bhuya, please ensure these things are done.
Yes, I will, my lord. I will.
my lord, my
No, you
You be there.
You be there.
my lord,
You be there.
my lord.
We'll see.
My lord, obliged.
And this acrimony, Mr. Chamua. Call Mr. Chamua. I'm done. A small boy in this all ego, a small boy is suffering. Yes. Yes.
I have read on your lordship's queries, my lord. Now, my lord had raised a query that at the relevant point in time, did the petitioners, my lord, at that point in time have the UGC qualifications? The answer would be no. Now, what had happened, my lord?
ये तारे बिटोर ओम प्रकाश बोले आता
My lord, Om Prakash, my lord, if your lordship desires, I have that. My lord,
Yes, what is your case? I
Yeah.
forgot everything.
your lordship had raised the query that without the 2010 regulations, would I have the regulations, would I have the requisite qualifications at that point in time? Now, my lord, what had happened is, since 1998, the qualification, the criteria had changed.
Nine,
Till
net 10.
1998, it was a mere
Net 10.
master's degree with a 55%, my lord. Thereafter, in the notification that the lordship has 2000, my lord will see the second page, my lord. Not the second page, my lord, the
What
annexure, lecturer, page 5. Your lordship sees that?
Oh. When were you all appointed?
I was appointed after these regulations came in, my lord.
2000.
I post that, my lord. Now, my lord will also take up a copy
All
of
the petitioners.
all the petitioners, my lord. All the petitioners, my lord. In fact, there is a chart, my lord, which you have appended. That chart, my lord, will find at page 28. All of my joinings, my lord, all of my joinings are, the earliest is in 2001. So, my lord, it is safe to say that as on the date of my appointment in the school by the governing body, I did not have the net qualifications.
Okay.
Now, I'll also go as far to prejudice my own case. My lord will kindly take up the advertisement copy, my lord. I don't know. I have the advertisement. My lord has that. Now, when applications were called for, my lord, at that relevant point in time, this is a sample advertisement, my lord, a sample advertisement of one of the petitioners.
Hmm.
My
We
lord,
have an advertisement at page 15.
page 15. my lord. Now, my lord will kindly also see, these are the advertisements which are floated by the colleges at their own discretion, my lord. Applications are invited for the following posts of lecturer and others in my own Ansolik College from candidates having latest UGC norms and other qualifications. Now, since the appointment, my lord, at that point in time were carried out by the governing body, respectively, although there was a reference to all UGC norms, my lord, however, my submission that deficit or venture colleges, my lord, at that point in time, did not look into the qualifications of NET, SLEP, MPhil, PhD, and irrespective of the fact that whether a
You have
candidate-
still not got the scale of pay.
No, I have been taken under the Act of 2017, my lord,
Hmm.
of tutors, my lord. And since 2020, I have been getting a pay of 27,000, which has subsequently been revised to rupees 30,000. Now, before your lordship,
You
there
have
was a-
not cleared the PhD or net till now.
because, my lord, I was under this bona fide litigation, my lord. Now, there's another submission, my lord, one small submission. This matter of Srimoi Bodu.
So in the writ petition, you have projected that
Well-
because you have acquired the MPhil
My
qualification,
lord, my lord.
so you must be given the, you
The
must be held to have satisfied the eligibility.
and there's a reason why, my lord, irrespective of the fact is, my lord, that the notification that exempts MPhil has to be read in isolation, my lord. The reason I'm making this submission is that Srimoi Bodu.
All have the MPhil qualification.
All have the MPhil qualification, my lord.
You also have.
My lord, will kindly take up one. Srimoi Bodu, my lord. In Srimoi Bodu, my lord, there was a categorical submission and a finding by the Honorable Division Bench that in the state of Assam, the UGC regulations are directory. Insofar as the fact that colleges are not sponsored by the UGC, my lord. The UGC regulations are directory. This is a categorical finding of the Honorable Division Bench of this court. my lord.
Yes, where do I get it?
My lord, I seem to have just prepared one copy. Paragraph 17.
No, no, I think I,
Paragraph 17 and 18, my lord.
Srimoy, I have, can have.
My lord, my lord. I apologize, my lord. I think
No, I have that, Shrimati.
too many, yes.
Yes, which?
My lord. Paragraph 17, ideally, my lord. It's a finding of the court. My lord will kindly come to page 11, my lord, paragraph 18. My lord. If I may permit it, my lord. If I may read, my lord. Paragraph 18 and paragraph 19. There you go. Para 23 may also be relevant, my lord. 23 and 24, my lord.
This judgment does not lay down any law.
It does not lay down a law, my lord.
It just discusses. And that issue was also not an issue which had fallen for consideration.
My lord, but what happens now, my lord? What happens now is that my lord will kindly come to page 459 for a moment, my lord. Page 459, my lord.
Page 4.
459, my lord. This is of the writ petition, my lord, item number 5.
Item number 5.
So it's like, item number 4, my lord. I apologize, my lord. Item number 4. Surajit Soikia. The notification, my lord, dated 22nd of March. Page 459. Page 459. Now, my lord, when I look at the judgment of Srimoy Bodloy, my lord, and the factual aspects that have taken place in the state of Assam, this notification, my lord, 22/3.
What about the acceptance by the state of the 2000 notification regulations?
No, but that does not change the fact that the colleges were never sponsored. by the UGC. That was one of the criteria which have been given.
Get it.
My lord.
But whether 2000 was accepted by the state authority,
That, my lord, my friend will have, because that was
Because
a query
see,
that your lordship had raised.
it is not a question of the qualification. Or this case, you don't have whether you will get the scale of pay of the UGC or something. It's not that. What the issue arising in this case is for recruitment as an assistant professor,
True, true.
whether you got to follow the UGC
Norms or not.
norms or.
No, no.
There can be no dispute after the decisions of Sushila and all of this is Supreme Court that those norms are required to be followed.
And I do not have those norms, my lord. There
You
is
don't have.
an admitted fact, my lord. But, my lord, please kindly see page 459 for a moment, my lord.
Hmm.
The notification that basically takes back what has been granted to us by way of the notification, my lord.
Because why it was been taken back? Because these two meetings
Yes.
of the UGC
My lord.
was subsequently not approved by the government and the Supreme Court in Sushila had dealt with that aspect, said that
My lord.
you don't have any right.
But, my lord, my submission would be that the first three paragraphs
Oh,
are redundant paragraphs. Barely because the state government has not in its totality adopted the UGC regulations. The first three reasons which have been attributed are redundant. My lord will only look into the last line. The aforesaid notification was withdrawn with effect from the date of issue of this notification. Now, this notification is prospective, my lord. By the very structure of the notification, the wordings of it, my lord, from this date onwards, my lord, it's a prospective notification. And that notification, my lord, by the very admission of the state, since it's prospective, it cannot take back what was granted to me by their own notification in the year 2010, my lord. And subsequently, many similarly situated teachers, my lord, have been provincialized, a list of which is appended in this petition. Now, the state has taken a ground that the UGC and the state regulations are vis-a-vis identical, which, my lord, to an extent, the state has disputed in its own words, my lord, in the matter of Srimoi Potile. Colleges are not UGC sponsored. Hence, the reference to the resolution that those meetings of the UGC were not held in proper perspective, those three paragraphs are redundant, my lord. A simple notification saying that the earlier notification is withdrawn would have sufficed. And the fact that from the date of issue of this notification, it primarily means, my lord, this notification is prospective. It could not have been, and more so in the light of the fact that, my lord, there are similarly situated teachers, my lord, mostly from the district of Karbi Anglong. The list is appended, my lord. They have been given the benefit. And if your lordship decides to not grant the benefits, my lord, then my lord will kindly grant the petitioners at least some residual time, my lord, to gather their qualifications. Because this notification, my lord, has been pending since the last 8 years, my lord. And we were provincialized, we were bought under the aspect of tutor only in the year 2020. 5 years had passed last year, my lord, and we may be given some scope to scale up, my lord. Because the governing body at that point in time, in spite of floating an advertisement in accordance with the UGC norm across the state, my lord, it has been not followed to the totality. Most people who have been regularized in provincialized colleges or government colleges, my lord, may or may not have had the net slate and fill in PhD. My friend would be.
how much time do you want?
Already Act has given 5 years, Lordship.
The Act has given 5 years.
Okay, how long do you want?
How long they can accommodate me?
You tell me, you know how far your intellect is with you,
My lord, true.
that I can acquire this qualification
Lord,
with it.
Even Lordship, in the month of December 1st itself, they can acquire, Lordship. Net and slate will come on.
That liberty has been taken away by my senior friend.
Oh,
But
forget
lordship has granted us-
Mr. He will say many things.
My lord will give us the 5 years which has been granted. If we finish it
Today.
before that, as on today, my lord,
Today, 5 years.
5 years onwards,
For 5 years, we give you, within that time, you will acquire that
my
qualification.
lord.
If you don't acquire.
Subject to the repetition not failing,
No, if you fail also, we give you that liberty,
my lord.
that within 5 years, you acquire that qualification.
We
Now
will
you
the-
don't acquire that qualification within 5 years. I'll have to get my order rounded up. I can't keep it open.
Then I can remain as a tutor, my lord, because that is what is the
Then
stipulation.
what
of
is the
Act.
point in, you go ahead, you acquire the qualification, come back to us.
No, because your lordship sees that we have been, there's an artificial
Because
class
Mr.
created, my lord.
Sharma,
My
if you acquire the qualification also,
My lord.
it will be only prospective from the date of announcement of the result
My
of
lord.
that.
So the hurry is on our part. So at least the 5 years will give us some bandwidth of comfort, my lord, but that is a separate matter. My lord will see that there is a.
Because they are not going to otherwise also remove you, because you are now a tutor.
My lord, I'm earning merely 30,000 based on a promise which was
That is,
given to
that
me by
is,
the
that
government,
is,
my
that
lord.
is your own
The
problem.
government within this 7 years had extended the benefit to certain classes. They've created two distinguishable classes, my lord, amongst the same pool of candidates. The list is there, my lord. The list has been appended, my lord. Lordship would see that's not a small list, my lord. That's page 251, my lord.
Because see, that and illegal, we are not going for a negative equality here.
But to an extent, negative equality cannot be extended to hundreds of candidates, my lord, and then just
can't
be
help it.
taken that.
Can't help it. We are not giving approval to that.
But the matter remains that there are people, my lord, similarly situated, but I'll not be disputing on that front, my lord. But the fact is, if your lordship finds the notification not to sustain, then at least, my lord, from the year, from the date onwards, my lord, that I should be given some chance to scale up, my lord.
So that period will start from when?
When your lordship issues the order, my lord,
Because
will-
the earlier thing has already left.
5 years, my lord, 5 years.
That has already left.
But we are under a bona fide litigation, my lord, before this court, my lord. We are under a bona fide litigation, my lord.
Yes, Mr.
Regarding that part, Lordship, I have no objection. It is discussion of the my lord's Lordship. that part.
We'll consider.
Otherwise, Lordship, it is fully covered by my lord judgment, as well as exactly similar set of employee approached before his honorable court. Exactly similar set, Lordship, Fensar Educational Institution. Honorable Court Division Bench has already decide the issue, Lordship. In Pollatku's case, Lordship.
But how they were provincialized under that 2017 Act?
17 as a tutor, Lordship.
The how? That is not applicable to them.
Tutor, Lordship.
Because the 2017 Act says
Yeah,
it
the
will be
provision is there.
applicable in case of persons
Lordship.
whose services of colleges, whose services have not been provincialized under any act. These colleges have been provincialized under the 2005 Act.
No, Lordship, 2011 Act, Lordship.
The colleges.
11.
Mr. Sharma, your college was provincialized under 2011.
11.
11.
Sure.
11, Lordship. Other two persons, death, Lordship. Death, Lordship, Upen in this Upen and Tulika in 2005, Lordship.
Are there two different cases, my lord? Upen and
Upen and,
Tulika-
Some cases I find
Lordship,
it is
Upen and
different.
Tulika 2005, Lordship.
But they have also been given tutor.
Lordship, they know, they are the conditional appointment.
That
They have to clear the net slate or PhD,
My
Lordship.
lord, page 105, my lord. The definition of tutor, my lord.
It is provision is there,
It's a
Lordship,
17 Act,
2017 Act, that's why they have given, and they have the chance to clear the,
Yes,
Lordship, the gestation period is 5 years period, Lordship.
okay.
that is
Where
It
is the?
it is there, Lordship.
rule
Who
6.
is appearing for Upen Kumar Sharma?
My
Upen
Upen
Kumar
Saha and
Saha?
Tulika Das, my lord. My senior appears, my lord.
Who?
My senior Mr. M.K. Chaudhary, my lord.
It's a conditional appointment is,
But the facts are slightly different. So my lord will kindly dispose these two matters, my lord.
No.
Honestly.
If we dispose, we'll dispose of all
My
together.
lord,
We are not going to write separate orders.
my lord, my
The
lord.
issue is same.
that particular issue, Lordship, that particular conditional appointment, Lordship, more than 15 single bench judgment is there. Recently, honorable division bench also, Lordship, passed a order, Lordship, that I just forward. Transit to
Tutors, my lord.
that Pranjit Kumar Sharma, Pranjit Sharma, that conditional appointment is there, that
Pranjit Kumar
Juno Devi and Pranjit,
I was there, I suppose. English, Pranjit Sharma, English department.
that
They will appeal to the equivalent of.
Juno Devi, Pranjit Sharma, all are, Lordship, conditional appointment, and that judgment fully covered this case, Lordship. And I will not rely on another single bench judgment, more than 15 single bench judgment is there, Lordship. Starting from my Lord Justice H. Roy, Lordship. Hmm? Here, their appointment order is, Lordship, in page 19, 2002, Lordship. he opened.
Open to it. No.
2003 and 2002, Lordship. It's a fully covered judgment, Lordship. There is a conditional appointment is there, Lordship. They have to clear net slate within
This
the.
is in some guilt is, yeah, my bunk. Yes, yes. I had appeared.
My one college, Lordships earlier dealt with that. Yes. Finally, after Lordships that side, this was another set of council, Lordship.
No, I was there in the single. judge.
Single, Lordship. Exactly.
So this will cover item number
Item number, Lordship,
2 and 3.
2 and 2, Tulika and Upen, Lordship.
And Surajit Saikya, you say that is there under the 2007 tutor.
2007 tutor, my lord, and
2017
under
also.
section 7, the tutors will have to scale up to be teachers within 5 years, my lord. And
That you want us to extend it for some time.
my lord,
And with regard to Mridusmita Gogoi,
That Surojit and Mirasmita same.
tutor,
Tutor.
tutor. Okay.
When was it that particular OM was considered by my lord in Umpokas
That we will.
by relying Lordship Biswajit Dekat
And so Sushila,
my lord Susila and Biswajit.
there. Do it in. Left. This is 7088, 2015. And WPC 7225, 2015. A2 code, sir, item number 7007255. 755. Heard Mr. M. Sharma. In both the cases, you will be there.
my lord.
M. Sharma, learned counsel for the petitioners in the above noted two writ petitions, and Mr. K. Gogoi, learned standing counsel, higher education department.
As well as
Hearing.
S Das also.
And Mr. S. Das, learned standing counsels, higher education department. The
And UGC
petitioners,
also there also.
Huh?
UGC also. there.
and also Ms. K. Pujari, learned standing counsel, UGC. The petitioners in the above noted two writ petitions have prayed for a direction upon the respondent authorities to authorize to their pay and allowances in the UGC scale of pay, by reckoning the MPhil qualification acquired by the petitioners in pursuance to the notification dated 1/1/2011 issued by the Education Higher Department exempting the persons who had obtained MPhil qualification prior to 30/7/2009. Also, the petitioners in the above note, I'm just not going deep into only the facts. The petitioners in the above noted petitions were initially recruited by the respective colleges against non-sanctioned post. Also, the petitioners after their such recruitment against non-sanctioned posts, had pursued their MPhil qualification. You had acquired it prior to 2009?
No, my lord, it's page 42, my lord, no.
Yeah, 11.
The admit card is it's 2011, my lord. 11 and
Had pursued
2011 both.
their MPhil course of study
Page 45.
either prior to June 2009 and or after and or in the year 2011, right?
Yes, 2011, my lord.
One of them is, I think, 2006-07.
My lord,
Page 47?
page 47, my lord, that is the admission card, my lord.
Okay.
The,
Had acquired, had acquired their respective MPhil degrees in the year 2011. Also, the petitioners do not, however, possess the net/slet, comma, and of PhD qualification. Also,
11 is a question.
the services of the petitioners were the orders that regularizing you,
but,
Page 37 and 41, Lordship.
petitioners were thereafter appointed against valid sanction post by the Director of Higher Education. However, in the orders of appointment issued to each of the petitioners in the above noted writ petition, comma, it was mandated that the petitioners shall draw a fixed scale of pay till they acquire the UGC norms. Also, the petitioners having continued in their respective services, comma, with by drawing a fixed scale of pay, fixed pay, comma, after the issuance of the office memorandum of the notification dated 17/1/2011, comma, wherein an exemption was given to the assistant professors in undergraduate level colleges from acquiring PhD acquiring net/slet and PhD qualification, provided they had obtained their respective MPhil qualification prior to 10/7/2019.
my lord, it should be 37, my lord. Ideally, it should.
No,
be
sorry, it 1/11/2011.
It, and it should be 111, the type.
1/11/2011. Huh? Prior to
10, 7.
30/7/2019. Also, the prayers made by the petitioners in this connection not having been considered and they being continued in their services on fixed pay basis, comma, the petitioners have instituted the above noted petitions praying for the relief noticed herein above. Mr. M. Sharma, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the notification dated 1/1/2011,
Yep.
that the exemption notification dated 1/1/2011 would also be required to be extended to the petitioners herein, inasmuch as the petitioners, after pursuing a course of study, had prior to the issuance of the said notification, had acquired their respective MPhil qualifications in the year 2011 prior to the issuance of the said notification. Accordingly, at the relevant point of time, the said accordingly, after the issuance of the said notification dated 1/1/2011, which had held the field till
22nd of March.
22/3/2017
70, page 459, my lord.
and thereafter was withdrawn with prospective effect, comma, the petitioners must be held to have fulfilled the requisite norms for drawing their pay and allowances in the UGC scale of pay, at least with effect from the date of acquiring the MPhil qualification. Full stop. Mr. Sharma has further submitted that persons similarly situated like the petitioner and who were also appointed against valid sanction posts by reckoning their MPhil qualification acquired by them, comma, were extended with the UGC scale of pay with effect from the date they had so acquired their MPhil qualification. However, a discrimination was meted out to the petitioners in the above noted writ petition by not extending to them similar benefits. That's your case,
That's my case. And the
Mr.
fact that, my lord, the notifications which have been relied on us, they stand alone and they stand independent of the UGC mandate.
Mr. Sharma has further submitted that the stand of the government being to the effect that it had not accepted the UGC regulations of 2010 in totality, comma, the notification dated 1/11/2011 1/1/2011 must be construed to be a exemption extended by the state respondents of the norms as prescribed for recruitment to the post of assistant professor. Mr. Sharma submits that the said notification dated 1/1/2011 having been withdrawn while the notification dated 22/3/2017, comma, such withdrawal not being with effect from the date of issuance of the notification dated 1/11/2011 and the same being only prospective with effect from the date of issuance of the notification dated 22/3/2017, comma, the notification having must be construed to have held the field from 1/1/2011 to 22/3/2017 and persons like the petitioners acquiring the MPhil qualification during the said period must be held to have satisfied the relaxed norms as formulated by the state respondents for recruitment to the post of assistant professor. Mr. K. Gogoi, Learned Counsel for the respondents, Learned Standing Counsel, Mr. K. Gogoi and Mr. S. Das, Learned Counsels appearing for the Higher Education Department in the above noted writ petition. However, dispute the submissions made by the Learned Counsel for the petition. Mr. The Learned Counsels at the outset submit that the contention of the Learned Counsel for the petitioner that the notification dated 1/1/2011 is a standalone notification would not mandate an acceptance inasmuch as a perusal of the same would go to reveal that the said notification was so issued in terms of a decision arrived at by the UGC authorities in its meeting held on in its meeting held.
Lord, It's 471st and 472nd, my lord.
Held in its decision of the UGC
My lord.
arrived at in its
471st,
471st and
472nd, my lord.
472nd meeting,
Resolution, my lord. Held
Resolution.
on 27 September 2010.
dated 27
September
September
2010.
2010. Also, Mr. Gogoi submits that the said resolutions adopted by the UGC were not, however, approved by the central government, and accordingly, the said resolutions to the by which the MPhil qualification was also held to be in satisfaction of the otherwise prescribed UGC qualification of net/SLET and PhD for recruitment as a assistant professor. Mr. Gogoi further submits that the Honorable Supreme Court, in the case of P. Sushila V. Dot versus P. Sushila versus V. Nalaga versus University Grants Commission, reported in 2015 8 SSC 129, had they considered the said issue and had held that the said resolutions of the UGC to be of no effect.
Regarding of the central government disapproval, my lord's judgment, paragraph 8, it is there.
Huh.
Paragraph 8, my lord's judgment. Paragraph 8. Ministry of Human Resource Communication, that is there, lordship. Paragraph 8, last.
এটা কাম কৰা এইটো কাটি দিয়া তাৰা 8 and 9 টো ইয়াৰ পৰা লৈ লোৱা। 8 and 9 টো Om Prakash Shah. Also, I have heard the learned counsel for FUSA. Mr. Gogoi has further submitted that the issue arising in the present writ petition would be covered by the decision of this court in the case of Om Prakash Shah versus State of Assam and others. Judgment and order dated 29/1/2024 in WPC 8035/2025 and
2017, my lord.
2017, and the decision of the division bench of this court in the case of Pranjit Sharma versus State of Assam and others, judgment and order dated 31/7/2026 in writ appeal number 331/2023 (over) and other analogous matters. I have heard the learned counsel for the parties and also the materials available on record. The issue arising in the present writ petition is as to whether the MPhil qualification acquired by the petitioner in the year 2011 would be permissible to be so reckoned for the purpose of holding that the petitioners had satisfied the requisite, had satisfied the UGC norms laid down for a recruitment as a recruitment against the post of assistant professor in an undergraduate college of the state. It is to be noted that the petitioners herein have admitted to the fact that they had acquired the said MPhil qualification only in the year 2011. However, the petitioners have placed a reliance on a notification dated 1/11/2011 issued by the Higher Education Department exempting candidates having MPhil degree prior to 10/7/2009 from acquiring the mandated qualification of net/SLET and PhD for appointment against the post of assistant professors in the colleges of the state. Also, at the also, considering the submissions of the learned counsel for the petitioners, comma, the petitioners having acquired their respective MPhil qualification only in the year 2011, comma, this court finds that even if the notification dated 1/1/2011 is to be held to have provided, extended an exemption to the MPhil holders, comma, with regard to appointment against the post of assistant professors, comma, the said notification having mandated that the MPhil qualification is to be so acquired prior to 10/7/2009, the petitioners not having acquired the said qualification prior to 10/7/2009, the cases of the petitioner cannot be held to be covered by the said notification dated 1/1/2011. Also, this court had an occasion to deal with the effect of the notification dated 1/1/2011 in the case of Om Prakash Shah Supra. This court, on considering the issue as well as the decision of the Honorable Supreme Court in the case of P. Sushila bracketed Supra, had gone to draw the following conclusions.
There are 13 onwards, also. There are 13 onwards.
13 over, huh? Not like 13, 15 over. 16, 17, 18, 18 over. Bishop 19 to Bativi 20. '21, 20, 21. Also, but the division bench of this court in the case of Ranjit Sharma Supra Ranjit Sharma is on a little bit different.
That conditional part was.
There is a
There also, there is a condition, there are also condition is that Lordship, net/SLET and PhD should be completed. Their appointment was in 2000.
because they were given that, then there was that increment was stopped.
No, Lordship, fixed pay was there, Lordship. Then also fixed pay was there. It is not reflected here, otherwise, Lordship, fixed pay was there, Lordship.
No, annual increments were regularly released. Some of the appellants were granted placement in the senior scale. And Departmental Promotion Committee also considered the cases. That's why I remember.
We have stopped it, Lordship.
Then you stopped it.
Lordship.
So, applying the decision of this court in the case of Om Prakash to the facts of the present case, this court finds that the petitioners herein are yet to acquire the UGC norms for being authorized their pay and allowances in the UGC prescribed scale in the UGC scale of pay. The petitioners are found to have not fulfilled the condition as set out in their respective orders of appointment against valid sanction posts, of having acquired net/SLET and or PhD qualification. The period mandated for acquiring such qualification in each of the appointment orders issued to the petitioners is also found to have elapsed over the period of time. However, the petitioners were continued within their respective services, and as projected by the Learned Counsel for the petitioners, they are still continuing to discharge their duties in their respective colleges as assistant professors in terms of the orders of appointment issued in their cases way back in the year 2000, all 2011, in the year 2011. So, in view of the above circumstances, the Learned Counsel for the petitioners have submitted that the petitioners having being bona fidely pursuing the present proceedings before this court since the year 2015.
Our case was 715, my lord.
15, both
and
are 15.
18.
15. Since the year 2015, and were under the bona fide belief that the MPhil qualification acquired by them would suffice for the purpose of authorizing to them their pay and allowances in the UGC scale of pay, the petitioners had not proceeded to pursue their net/SLET and or PhD courses. Accordingly, the Learned Counsels for the petitioners, Learned Counsels for the petitioners in the above noted writ petitions have prayed that the petitioners be given an extended period of time for acquiring the UGC norms for recruitment against the post of assistant professor in terms of the stipulation made in this connection in their respective appointment orders.
That part was also said in the paragraph 32, 33 and 34 division bench, so the my lord may kindly.
But that was a discretion which has been granted. I'm seeking benevolence, my lord, more than. I'm seeking
32,
utility, my lord.
33 and 34.
I've gone through that judgment, my lord.
Same advocate,
Lordship.
My lord, my
Mr.
senior
M.K. Chaudhary.
my-
Also, considering the said prayer made by the petitioners and also appreciating that the present proceedings were pending before this court since the year 2015, this court directs the petitioners to approach the authorities in the higher education department with a prayer for granting to them, but that will be suicidal. Continue. Considering the said prayer of the petitioners, made by the petitioners, and also appreciating that the present writ petition is pending disposal before this court since the year 2015, it is provided that the petitioners shall endeavor to acquire the requisite UGC norms, that is net/SLET and or PhD qualification within a further period of 5 years from today. However, it is clarified that without acquiring the UGC norms, the petitioners shall not be entitled to the UGC scale of pay, and it is only from the date they would acquire such qualification that the petitioner's entitlement to draw their pay and allowances in the UGC scale of pay prescribed would arise.
And my qualifications, my lord, if I do undertake to satisfy all those UGC norms, my lord, that should be as per the 2010 regulations, my lord. Since my appointment was there, I've been in service, my lord, for 25 years.
UGC norms, as holding the field on the date the petitioners were issued with appointments,
My lord.
orders, appointing them against a valid sanctioned post of assistant professors. Anything more?
I'm grateful, my lord.
Then also 10 lordship, even 16, same lordship, nothing will change.
Nothing is going to happen. They
Loss.
retire like that.
Lordship, lordship.
Next.
My lord, the petitioners in item number 3, my lord,
Hmm.
their MPhil was done in 2010, since your lordship had taken up Upen Kumar
Oh.
Saha.
2010
2011.
oblique 2011.
10.
Yeah.
Yes.
After 110.7.
All are, lordship, lordship.
But ours, my lord, in item number 4, Suryajit Soikia, all of us have satisfied that criteria of having passed our MPhil prior to,
2009.
but then
And
your
what-
lordship had
no, no,
read down.
no,
Yes,
no.
yes.
And what about this 5 item number Smita Gogoi? When did she do? Prior to 10/7/2009.
Prior to my lord,
Take up.
my lord. Time to see my lord.
So lordship, may Surajit Sokia kindly page 118 lordship. 118 lordship. 118, madam may kindly page 120 lordship, page number 120 lordship. 120, provisional certificate 15 June 2011 lordship. Not a single person lordship.
Examination June 20, 2009.
Lordship, provisional certificate, they have completed on 15 of June 2011 lordship. Then my lord make course completion in respect of Nilima Thakuria 14, all are after 11 lordship.
Then I take back my submission. my lord. I
All are
apologize.
after 11, up to 14 lordship, not a single person lordship.
Item number 5, my
Yes,
lord.
on
Kindly
the
see my lord.
No, no, no.
Lord, MPhil degree obtained on 7/4/2009, my lord. Page 15, my lord.
7/4.
My lord, but clerically, my lord, it was shown, my lord, after, my lord, 1/10/2009, my lord. Date of issued, my lord, on the basis of date of issue of the certificate, my lord. Only see, my lord, page 18, my lord.
But Mr. M. Sharma,
Even lordship, then Pollard Kusil lordship covered a business.
Pollard.
Pollard Kusil covered lordship.
On as MPhil after 10/7/2009.
Even if he is for a moment lordship, suppose we hold that lordship obtain MPhil degree in 2002 also lordship, then we'll cover Pollard Kusil.
Prahlad Kosh, Om Prakash,
Om Prakash lordship, everything will cover. Their case
Left.
will no.
Hut, Mr. Item number 4 and 5. M. Sharma, Learned Counsel, appearing for the petitioners in WPC number 4703/2018, and Mr. K.R. Patkiri, Learned Counsel, appearing for the petitioners in WPC number 4625/2020. Also heard Mr. K. Gogoi and Mr. S. Das, Learned Standing Counsels, appearing, Learned Standing Counsels, Department of Higher Education Department, comma, Higher Education Department, and Ms. K. Borpujari, Learned Standing Counsel, UGC. Also. Huh? Not a party, both. Nalagay. Also. The petitioners in the above noted writ petitions have prayed for a direction upon the respondent authorities for provincializing their services against the post of assistant professor in terms of the provisions of the 2017 Act. Huh? Same prayer?
Her service was provincial as a tutor in under 2017. It's
17,
exactly
but
same.
same.
Exactly same. Your Worship.
My lord, I've made a submission, petition, that as on the date of joining our colleges, it was prior to 2009, I held all these MPhil degrees. That's why I made the submission, they're relying on.
Okay, okay,
My lord.
okay, okay.
Certificate.
The prayer of the petitioners in the above noted writ petition for reckoning the MPhil qualification processed by them is based on a notification dated 1/1/2011 issued by the Government of Assam in the Higher Education Department, exempting holders of MPhil degree, acquired prior to 10/7/2009 from possessing the net/SLET or PhD qualification, which otherwise is the mandated qualification for a recruitment to the post of assistant professor in undergraduate colleges in the state. As projected in the writ petition, the petitioners were recruited as assistant professors by the respective management committees of the colleges to which the petitioners were initially appointed. During the period, the petitioners were so appointed by the respective managing committees, the colleges wherein the petitioners were so appointed were in its venture stage. Thereafter, on the enactment of the Act of 2017, hereinafter referred to as 2017, the colleges wherein the petitioners were serving, having been found to be eligible for the purpose of provincialization of the services of the teachers working in the said colleges, the names of the petitioners being approved by the constituted committees, the government proceeded to approve the cases of the petitioners for provincialization of their services as tutors. Accordingly, the Director of Secondary Higher Education issued consequential orders appointing the provincializing the services of the petitioners as tutors under the provisions of the Act of 2017. The petitioners have thereafter instituted the present writ petition, praying for the reliefs noticed herein above, by contending that considering the MPhil qualification possessed by them at the time when their respective cases for provincialization was being so considered, the petitioners were required to be provincialized in their respective services as assistant professors in the UGC scale of pay prescribed and not as tutors on fixed pay basis. Mr. M. Sharma and Mr. K.R. Padgiri, Learned Counsel for the petitioners, have submitted that the petitioners on the date they were so recruited. You had the MPhil qualification
We had.
or recruited in their respective colleges and or prior to 2009 had acquired their MPhil qualifications. Accordingly, it is submitted that in terms of the provisions of the notification dated 1/1/2011, comma, the petitioners herein having come under the exempted qualification now prescribed for a recruitment to the post of assistant professor in undergraduate colleges of the state, comma, the respondent authorities ought to have proceeded to provincialize the services of the petitioners against the post of assistant professor by also authorizing to them the UGC scale of pay in lieu of the provincialization effected in respect of each one of them as tutors with a fixed pay. So, accordingly, the learned counsel for the petitioner submit that the petitioners herein that this court would be pleased to direct the respondent authorities to provincialize the services of the petitioners with effect from the date their services were so provincialized as tutors, comma, as assistant professors, and authorized to them their pay and allowances in the scale of pay, in the UGC scale of pay as prescribed. Also, Mr. K. Gogoi and Mr. S. Das, learned senior, as learned standing counsels, Higher Education Department, however, at the outset dispute the date of acquisition by the petitioners of their respective MPhil qualification. Having disputed the said dates, they disputed the date of acquisition by the petitioners of their respective MPhil qualification. The learned counsel for the respondents have submitted that even if it is construed that the petitioners had acquired such qualification prior to 10/7/2009, comma, the same would not mandate, would not be, but same cannot be reckoned for the purpose of construing the petitioners to have also satisfied the UGC norms prescribed for recruitment against the post of assistant professor in an undergraduate college of the, in undergraduate colleges of the state. Also, Mr. The learned counsel for the respondents have submitted that the notification dated 1/1/2011 was so issued in pursuance to the resolution adopted by the UGC in its 471st and 472nd meeting held on 12/8/2010 and 27/9/2010, comma, exempting candidates having MPhil degree, who have acquired MPhil degree prior to 10/7/2009, comma, from possessing the mandated net/SLET qualification. Actually, I'm breaking 90. Para 8 or para 8. A upoto to 8 for my dividend. Para 8A to para 9 and B. A to A, huh? Para 8 or Aadhaar for us. Continuation of it. So, I've heard the learned counsel for the parties and perused the materials available on record. This court would proceed in the matter by reckoning, by holding that the petitioners herein have all acquired their respective MPhil degrees prior to 10/7/2009. We have construed. So, accordingly, the petitioners have projected that in terms of the notification dated 1/1/2011, comma. The petitioners, having acquired their MPhil qualification prior to 10/7/2009, comma, must be construed to have acquired the relaxed qualifications, to have satisfied the relaxed qualifications for recruitment against the post of assistant professor in undergraduate colleges of the state. The cases of the petitioners were admittedly considered under the provisions of the Act of 2017. The respondent authorities, upon consideration of the cases of the petitioners, having come to a conclusion that the petitioners did not satisfy the UGC norms, did not possess the UGC norms mandated for recruitment against assistant professors in undergraduate colleges of the state, had proceeded to provincialize the services of the petitioners as tutors, with a further condition attached requiring the petitioners to acquire with a further condition attached that on accusation of by the petitioners of the UGC norms, comma, they would be entitled to be authorized their pay and allowances in the UGC scale of pay, followed by along with their appointment as assistant professors prospectively. The issue as to whether the notification dated 1/1/2011 had brought into operation a valid exemption of had laid down a valid exemption from possessing the UGC norms in respect of candidates who had acquired their respective MPhil degrees prior to 10/7/2009 was examined by this court in the case of Om Prakash Shah versus State of Assam and others, judgment and order dated 29/1/2024 in WPC number 8035/2017. This court, on an examination of the said matter, had drawn the following conclusions. Para 13, 14 to 15, 16, 17, 18, 19, 19 to drop COVID, .dv, 20, 21. 21. Further, the division bench of this court, in the case of Prahlad Konch and others versus State of Assam and others, reported in 2017 3 GLR 56. Para 9 onwards, no, Mr.
15,
Para 9, sir.
Yes.
Para 9, 10, 11, 12, 13, 14, 15, 16, 17,
18.
18.
Lordship.
Oh, sir. The petitioners herein also being similarly placed like the petitioners in the, like the appellants in the, like the petitioners in the case of Prahlad Konch and Om Prakash Shah, comma, the decisions rendered by this court in the above noted two cases would also squarely apply to the facts of the above noted writ petitions. So, the petitioners, in view of the above conclusions reached by this court in the above noted two decisions, comma, cannot be held to have satisfied the UGC norms prescribed for recruitment against the post of assistant professor in a assistant professor in a provincialized undergraduate college of the state. Accordingly, the claim made by the petitioners in the present writ petition for being appointed as assistant professors with effect from being provincialized as assistant professors, comma, with effect from the date they were so provincialized as tutors, comma, would not mandate an acceptance from this court. It is provided that the petitioners, on acquiring the requisite norms prescribed for appointment as assistant professors, as was prevalent on the date they were so provincialized as tutors, comma, the respondent authorities shall extend to the petitioners with prospective effect the pay, UGC scale of pay as prescribed for the post of assistant professor. It is clarified that in the event the petitioners acquire the UGC norms mandated, comma, they would be entitled to the UGC scale of pay only prospectively with effect from the date they have acquired the net/SLET and/or PhD qualification. With the above observations and directions, the present writ petition stands disposed of.
My lord, because of issued in 2 and 3, madam, the standalone part of it,
We
madam.
have done.
Madam, since the judgments are connected, my lord, or these are
No, two different judgments.
2, 3, and 4 and 5 are separate.
2, 3, 1, 4, 5.
Madam, I'm grateful.
Alright. Elizabeth.
So some 16, 18 matters gone.
Lordship.
Any
Yes.
IA, any IA?
No, Lordship.
This was done by the way. Wow. Taking it to me after 2 years. Yeah. File button.
I have seen, yes, I got the message, madam.
Nothing.
We are not entitled for closure benefit. Madam. So, para 16 your lordship, 14 your lordship kindly see.
Para
Para 14, my lord.
of
My page 37.
para.
After it, page 37.
Hmm.
Para 14. So that is my step.
No, you tell me whether you're entitled to this closure benefit.
No, that's why I'm submitting.
You're not
No,
entitled.
No, who am I, my lord? I'm just
Oh.
that.
We'll just close it, saying that the petitioners have examined the matter at various stages, and Mr. Mr. T.J. Monto, learned senior counsel, fairly submits that the cases of the petitioner may not be, the petitioners may not be eligible for the closure benefit. And we'll say that he says that the petitioners being master role, casual oblique seasonal employees, whatever benefit was there was given to them. Heard Mr. T.J. Monto, learned senior counsel, assisted by Mr. P. Burwa, Burwa, learned counsel for the petitioners. Also heard Mr. G. Bordoloi, learned standing counsel, Cooperation Department, appearing for the state respondents, right? The petitioners in the present writ petition have prayed for a direction upon the respondent authorities for authorizing to them closure benefits, comma, in the form of VRS
And other.
and
yes.
other benefits in pursuance to the closure of the Assam Cooperative Sugar Mills Limited. Sugar Mills Limited, where was it? Gulakat.
No, that is Delgaon in Gulaga district.
Gulakat. Limited, comma, situated at Borua Bamut Gaon,
Gaon.
comma, Gulakat.
District of Gulaga.
Fosso. The Fosso. At the outset, this court would notice that in the present writ petition, comma, would notice that in terms of the directions passed by this court, wide order dated 23/11/2015 in WPC number 1930/2008 and other analogous matters, comma, the liquidator, comma, Assam Cooperative Sugar Mills Limited had issued orders in respect of, speaking orders in respect of each of the petitioners, determining their entitlement to the entitlement upon the closure of the said mills. In the said speaking orders, it was categorically mentioned that the petitioners, being casual workers working on daily wage basis, were paid the arrears of their such wages and were not entitled to any further benefits upon closure of the said sugar mill. The said position was reiterated by Mr. G. Bordoloi, learned standing counsel, Cooperation Department. And it was highlighted that the petitioners, being only casual workers employed on daily wage basis, comma, the petitioners were not entitled to the VRS benefits as was extended to the regular oblique seasonal workers of the sugar mill. Mr. T.J. Monto, learned counsel for the petition, had on the last dates of listing prayed for an adjournment in the matter to examine the issue closely. Mr. Monto, on examination of the issues involved, has submitted that the petitioners in the present writ petition have not been able to demonstrate, has fairly submitted, not been able to demonstrate that they are also entitled to any further benefit than that as disclosed by the liquidator in the speaking orders issued to each of them. Mr. Monto has submitted that the petitioners being casual workers, comma,
No, their master rule, casual and seasonal.
master rule workers, comma,
Casual and seasonal.
casual and seasonal, comma, they being paid a fixed, they being paid daily wages, comma, the scheme as in vogue, as a scheme under which the VRS benefits were so released to the other regular employees of the sugar mill, comma, is not found to be applicable to the petitioners hearing. Also, in the premises aforesaid, Mr. seasonal লিখিছা নহয়, temporary seasonal workers. আর উপৰত এটা আমি seasonal লিখিছো নহয়, এইটো permanent seasonal work.
Yes, permanent. They are permanent. These are master rule.
কি লিখিলো লাষ্টত? Mr. Monto submits that the claim made by the petitioners in the present petition may not justify an acceptance by this court. Also, I've heard the learned counsel for the parties and also peruse the materials available on the court. Considering the fact that the petitioners herein were appointed as master rule, comma, casual, comma, temporary seasonal workers, and they being found to be entitled only to a daily wage for the date they had so served, comma, the petitioners herein cannot be elevated to the status of a permanent employee in the said sugar mill prior and or a permanent seasonal worker working in the said sugar mill prior to its closure, and accordingly, the petitioners herein would not be entitled to any VRS benefits, inasmuch as the petitioners are not found to have been authorized a salary for the purpose and or were in a salary for the purpose. Full stop. Accordingly, the speaking orders issued in respect of each of the petitioners by the liquidator, comma, Assam Cooperative Sugar Mills Limited, comma, would not mandate an interference from this court. Having drawn the said conclusions, comma, this court reserves the liberty with the petitioners that in the event any further material comes into their possession, which would highlight an entitlement to receive higher benefits, comma, the dismissal of the present petition would not stand in the way
My lord.
of the petitioners to claim such benefits. In the event such claim is made or basing on cogent material, comma, the respondents, including the liquidator of the sugar mill, shall give a due consideration to such claim and take the matter to its logical conclusion. With the
Yes, sir.
above observations and directions, the present petition stands closed.
Fine. Good night.
I have also seen there is
Yes,
not
my-
even a
that's-
something to pick up. It's not there.
My pro bono case, my lord, they are very high.
Can't help it. That's why.
Long,
Not-
they are working for 13, 14 years as a
But
casual labor.
That
Got nothing. But
that liberty.
yes, yes, my lord, if
Get
found
something.
anything, they will come.
Mr. Borwai, get
Yes,
something.
ma'am. Deep look.
File a review in this also. I'll open
My
it.
lord.
Don't do it.
No, please, your lordship. Lordship, in item number 43, lordship,
Huh?
in item number 43,
Oh,
yes, item lordship, the boy is suffering from measles, lordship.
Measles.
Yes, lordship. So he may not be go to the school from tomorrow, lordship.
When can he go?
At least 10, 15 days it will take.
কোনে মাৰিছিল? হেৰি এই লাইন দেখিলো আছে, এইটো লাইনটো কাটি দিব দিবা। The petitioner is to join tomorrow না, হা এইটো কাটি দিবা, কাটি কেনে তাইক ক'বা যে লিখিব the petitioner who is submitted to be suffering from who is submitted to be indisposed shall resume his classes moment he becomes fit for the purpose.
Nice.
My lord, herein I am challenging the impugned termination order, page 43. My lord, 43.
What is this college? It's a provincialized college.
Provincialized.
Yes, what is your case?
My lord, his services were confirmed in the year 2002.
Hmm.
My lord, lordship may kindly come to page 18, my lord.
Hmm.
And his services were regularized with effect from 25/3/1998.
Hmm.
Initially, my lord, he was applied for lien, my lord. If lordship may kindly come to my lord,
Okay, give me a particulars.
my lord, petitioner was appointed as lecturer in chemistry on 23/10/1998 at a consolidated salary of rupees
22?
1200 per, my lord.
Date.
Date 23/10/1988, my lord.
Then
My lord, thereafter on 27/3/1998, my lord, his name of the petitioner along with other lecturers were accorded sanction, my lord, for temporary appointment.
page.
Page 15, my lord, annexure 2. 99.
So earlier appointment, you did not get any scale of pay.
No.
Then
Thereafter, only page 18, lordship may kindly come.
Hmm.
It is the confirmation letter, my lord. Page 18.
This was a deficit granting in college.
My lord.
Deficit college.
Yes, my lord.
Then
Now, lordship may kindly come to page 21, my lord. He was as a, my lord, head of the department of chemistry.
Naturally. Then
And thereafter, my lord, lordship, that is, my lord, draw the senior scale of pay, 10,000 to 15,200, annexure 5, my lord, 17/5/2004.
27/5/24.
Yes, page 23, lordship.
23.
Yes,
Senior scale of pay. With effect from
senior scale with 17/5/2004, my lord.
8/2/2000.
My lord, sorry. 8/2/2004. 2004.
Right?
Lordship.
Then
8204. 8204, my lord. 8204, 2000.
8/2/04.
My lord, thereafter, my lord, petitioner in the year 2009, my lord, applied for PRS. Although that was cancelled, rejected, only because that, my lord, as per their contention, although I have not completed 20 years of service.
You have not completed.
Page 24.
But same rejected.
Now, lordship may kindly come to page 27, my lord. Sorry, page 28, my lord.
24.
Superannuation pension. Page 28.
8.
Yes. Superannuation of pension, clause D, my lord. Qualifying service for receiving full superannuation pension shall be 25 years instead of present 33 years. Proportionate pension shall be given to those employees who have completed minimum 26 monthly periods of qualifying service, but less than 56 monthly period of qualifying service. The provision shall come into effect from 1/1/2006. He applied. by way of this writ petition, my lord, he is praying for proportionate pension.
Okay, then what happened?
My lord. Then suddenly, my lord,
Hmm.
impugn order lordship may come, my lord, page 43. Initially, my lord, he was applied for year, but that was not approved. If lordship may kindly come to my lord, page 36, lordship.
Hmm.
My lord, before issuance of termination order, no DP was initiated against him. No show cause, even no show cause was issued to him. Lordship may kindly come to page 35, my lord. This is the report. Report of the case related to the unauthorized leave of Miraj Khan and action taken by the college. Page 37, yes, sir.
Hey, division bench auto महिला नहीं. Where is the order?
Which one, madam?
Annexure 15.
Annexure 15, 43.
What is the stand?
My lord, they have rejected, my lord.
No, what is the stand taken in the affidavit?
Affidavit. Hmm? So 4 and 5, para 8 onwards. ma'am.
So did you go to Qatar?
Subsequently, my lord,
You went to Qatar.
but I applied for leave, my lord.
Ah.
That was not approved.
Very good. Now tell me, how did you go to Qatar? Where is your station leave permission? You have violated 13th. Abandonment
applied
of
for
service. You
station
have
leave.
abandoned your service.
I applied for the station leave permission, my lord,
It
but
was
that was not
granted.
approved.
How, why did you proceed? Are you, can you? Yes, sir. Assam services, man.
844 was.
Come to rule 8, conduct rules.
My lord, lordship may kindly come to page 40, my lord, clause number 11.
Hmm?
Para 11, my lord. 23/6/2009, he dropped an application for station leave without specifying its address of destination, etc.
Forget it.
And left the college
station
without
leave will
obtaining
not
any.
do. Mere station leave will not do. Come to the provisions of twelve. Conduct rules.
Yeah, confirm.
The last few words, and any other employment shall not, without the prior sanction of the government, indulge himself in trade, commerce, and any other employment. Now, this thing would come within the term any other employment. If it comes within the term any other employment, we will deem that you have abandoned your services. Yes, Mr. Das.
My lord, I have record also, my lord. It will show that when he applied for lien and there was nothing mentioned where he is going and
Get it? How can you terminate his services without an inquiry?
my lord, what had happened before sanction of lien, my lord, he left the college. Thereafter, several letters were sent, my lord, records are there. Several letters were sent. He once thereafter came and filed one
Again
application.
went.
Then again went, my lord. He even vanished, my lord. Then thereafter, my lord, after some years, he filed one application, station leave, but he did not mention the address. So when the authority did not know about his whereabouts, my lord, the authority, the college authority, my lord, made a paper publication and asked him to join the college. Even then also, my lord, he did not join the college. So he has been unauthorizedly absent since 2009, my lord.
And he was terminated within 1 year.
Resolution was taken in by the governing body
2010. And
2010.
you approved it with
approved in
retrospective effect.
My lord, in 17.
Yes, Mr. Chaudhary.
My lord, retrospective effect, whether it is permissible under the law.
That is approval.
It is, my lord,
That is
20,
approval.
20 order, my lord.
That is approval.
17.
Now tell me, show me that today we ask a departmental proceeding to be instituted against you.
Now it is not possible, although I am 64 years of age.
I use my
At that time,
powers.
58.
I use my powers 2006. I
It is
direct.
there, my lord.
What will you establish? What will you establish? Moment your passport is produced, everything gone for a 6. Moment you produce your passport before the inquiry officer, your absence from India would be apparent like daylight. So we dismiss this, saying that you had abandoned your services.
My lord, relying upon the judgment. I understand, my lord, there is a misconduct on my part. Understand, my lord, there is a misconduct on my part. But then also, my lord, EP should have to initiate an action.
I'll find out a way.
At least notice. At least, my lord, notice should have been initiated.
They have published notices in the newspaper.
One second.
Satisfy me, give me materials to draw.
And in fact, my lord, if lordship may kindly look into their, my lord, paper publications, if lordship may, as per section 82 of CRP, 2 paper publication is required. Herein they have published only 1. And whether they
Okay.
have sent a registered, my lord,
But Mr. S. Chaudhary, Learned Counsel for the petition. Also heard Mr. S. Das Leonard, planning council, Higher Education Department, and Miss so and so appearing for the respondent number 6. Hearing remains inconclusive. Registry to list this matter again. Nine.
And Lordship may kindly keep this judgment. Notice is required. To serve.
The further hearing. They are only in conclusion, registry to list this matter on pool 9 for further hearing. Sir, yes.
If it is not inconvenient, your office, Lord, may I pray that items 26 and 27
Huh.
of it is today. Yeah, admission matters, my lord. Can it be taken up at after some, I heard there is a developments for.
There is a one
pronouncement.
order to be, the judgment will take 5 minutes. Then there is a Arunachal matter, Patad matter, otherwise inconvenient.
No, you have nothing there. They cannot have.
Sir has said that there is some urgency. We will hear him. And if we find that it's time should be given, we'll give. Otherwise, we'll pass orders.
Yes, yes, obliged.
Because Mr. Cholia, the problem is that there are
I have
many
seen the
matters
list.
of 2015, 16.
I've seen
So I
that.
thought I'll just,
Yes,
let's clear up some space there.
yes.
Okay. 2 o'clock we'll have the division bench. Tar pisot he Arunachala matter. Tar pisot Saro matter.
The conviction of the appellant is altered to the first limb of section 4 of the POCSO Act, that is 4(1). And he's sentenced to undergo rigorous imprisonment for 10 years. And the fine is left untouched. The criminal appeal stands dismissed subject to the aforesaid modification in the conviction and the sentence.
Obliged.
Any further arguments?
I understand that it is concluded.
Yes, any further arguments?
No, Lordship just wanted to apprise regarding one recent judgment
Ah.
of Supreme Court that I will transmit that judgment through PS, Lordship.
When, what is that judgment?
Judgment is in regards to Bihar Cricket Association, Lordship.
Have you given it?
Lordship, I have given it, but whether he has got it or not, Lordship, I have to ascertain it.
Can you just send it?
Lordship, I will send it, Lordship.
No, yet I say, Pelto told us. Keuzia wrong of Peltos. You don't trail on it. No, I've not received it.
Lordship, I'll send it, Lordship. Lordship, I have also filed one written argument,
Given
Lordship.
a written argument along with a pen drive.
All right, Lordship.
And the written arguments of the respondent number 1 and 2 are here.
Okay.
But I am not privy to anything like that, my lord. If something is provided in pen drive, my lord, I do not know.
Why have you not given a copy to the petitioner?
Lordship, I just, I'll provide Lordship.
Heard the learned counsel for the parties at some, heard the learned counsel for the parties. The learned counsel for the petitioner has filed a written argument and therein has enclosed a pen drive purporting to demonstrate that the petitioners had raised objection with the manner in which the elections in question were conducted. Mr. S. Dr. Learned Senior Counsel appearing for the respondents has submitted that the said pen drive has, however, not been furnished to him. The Learned Counsel for the petitioner submits that he would furnish the copy furnish the said pen drive, copy of the said pen drive, furnish the video footage in a pen drive to the Learned Counsel for the Learned Counsel assisting Mr. S. Dr. Learned Senior Counsel, appearing for the respondents by tomorrow.
Tomorrow, Lordship.
There is anything, then nothing to be submitted, I suppose, after this.
My lord, I do not know if they have raised something beyond pleadings, my lord, I do not know. But otherwise, I understand that it was concluded.
So, in view of the above development, registry is directed to list this matter. Khali Kundina se next week. Adha ghanta 45 minute. 3-9.
3-3, I'll be in Itanagar itself. my lord.
Okay, then 7-9.
Okay.
Bags are too many in number, so it will be very difficult for a day.
No, my lord, because of the combination now,
Not understood. What do you mean? What I meant? Oh, you don't know. You'll reach that level soon. Bags.
no, my lord, only this is the volume.
Bags. Yes, next, where is the empty day bag? When there is no bag.
9th of September.
9.
Sorry, my lord. Yes, 7th of
7-9.
7.
2026. We'll deliver the order on that thing. Now, something is there, 5 minutes. We'll deliver the order.
Lord.
If I'll get a mug. For further hearing. Tentatively, it boils down to 1.
Yes.
Tentatively.
Lord.
Boils down to 1. Others, again, in a mystery. We'll see.
Lordship, I have given the written argument, Lordship. May kindly go.
Fine. We have gone to.
Lordship. Obliged.
Tulia sir. Material. Yes, Bishop. Yeah, Bishop Mukhe. Agree.
You will see the last order. Ask Nicholas. The court as the reasons for by which the petitioners were terminated and whether any notice, etc. were issued prior to the termination. Last order.
Miss.
Yes, Lordship, I appear.
Well, you are for the college.
Yes,
Why did you terminate?
termination was in pursuance of the government letter, Lordship. That Lordship will find at page 25. Annexure G.
Annexure J of?
Annexure G in the first repetition 2650.
Page?
Page 25.
Understood. You can answer.
When was this college provincialized?
15,
Huh?
13, 2013.
13. Where do I get that?
That, sorry, I can mention this.
When was your college provincialized?
That lordship by that instruction.
In the first case at page 14, your lordship will see the advertisement for the appointment, for these appointments, local advertisement.
So they were appointed under the college was provincialized under the 2011 Act.
Yes, yes.
Now, whether your case was considered under the 2017 Act.
No, my lord, under this act also, there is a provision for,
I was appointed on 15/4/2010, lordship.
Then, so that you will not be covered under the 11 Act.
under the 10 rules,
So under the 11 rules, you are not covered, Mr. Chulia.
till then, the governing body is the disciplinary authority. In case of provincialized colleges.
How much are you being paid?
That some payments were made, right? Lump sum payments were made. Advertisement says the posts were lying vacant. This is not the case that they were ad hoc or
Where is the advertisement?
at page 14 in the first case. 2703.
So when was this two petitioners here? Two cases are there, 2650.
Yes.
When was he first appointed?
During
In 2650 annexure 16, page 16. 2650 annexures, annexure A, page 16 and page 18 are the appointment letters. Annexure A and B.
Both are lecturers.
Yes. After approval from the university, posts were created, object was given, then posts were created, and thereafter they were appointed. that I mentioned in it.
And in the second case,
Second case, they were grade 3 and grade 4.
Page 15.
Where page 15 appointment letter. And any provincial inquiry still now look, the system is governing body is the controlling authority. They are the appointing authority, they are the disciplinary authority, and the principal is only secretary of the governing body. Has to be taken by the governing body, then only he will forward it to the government, then government will, if they get, then the termination or other things can be done.
okay. Yes, Mr. Chalia,
Well,
you're not entitled even to be provincialized under the 2017 Act. Because 17 Act, the cutoff date is 31/12/2010. You were appointed thereafter. You were appointed in 2011. It's a provincialized school. So whether you have to be continued with or not, that is for the governing body to take care of, not for the government to say anything. Now, the order that under which you were terminated, what do you have to submit on that?
order 6 of it speaks of prohibition in the government letter, my lord. You also will see strict compliance of prohibition of engagement of contractual staff for teaching and non-teaching purposes without sanction.
Now, you are not eligible to hold a sanction post.
No. First thing is, we were not engaged or being engaged as on contractual basis.
Be that as it may, you were engaged in a venture education institution. Now, after the venture institution has been provincialized, your case was not considered, cannot be considered because you are post.
They have some criteria then.
That you don't fulfill. So your services will not be permissible to be continued with. Now the question is where you are continuing prior to the date of provincialization, whether you can be allowed to continue till the necessity is there. Now, how many you are?
But the necessity is always there because they were the only teachers there in the college teachers.
Any employee provincialized as grade 4, grade 3 in the college?
Yes, that was under that act.
2018 Act, not 17. Yes. How many teachers have been provincialized against the subject of the petition?
That instruction.
What is this? Whatever I ask you to know, you are for the college, you should know everything.
Affidavit, Lordship. Let it come up after a week, Lordship.
No.
We'll have the
Today.
entire instruction. Otherwise, Lordship, what we have done, Lordship, we
Only
have
copy
acted.
pasted the government.
No, we have acted
Yes,
on the
Mr.
basis of
Good.
the.
These persons were appointed in the venture stage. And they admittedly are not entitled to be
Within the
provincialized.
within the cutoff.
Cutoff mark, 31/12. But if there is a need, necessity
Lordship.
to maintain that people-teacher ratio and all those things of the
Here
university.
they are the grade 4 employee, Lordship.
No, they are teachers also.
Teachers also.
Teachers
And
grade 4.
if the grade 4 has not been provincialized,
Grade 4 provincialized, even 2017 Act also provincialized.
so it will be 18 Act,
Sorry, 2018 Act also provincialized. Lordship.
provincialized. Where are those orders?
Here, this order is not the other is provincialized. Lordship.
Provincialized.
Provincialized. In every colleges, Lordship, provincialized. Only
but still-
librarian post is not provincialized. Lordship.
And in the subject wherein the petitioners are the teaching, in the Abdul Sakar 2650,
Key subjects, sir?
therein how many teachers were or lecturers were provincialized for the subject
Philosophy, Lordship. Philosophy and Arabic.
philosophy
Arabic,
and Arabic?
Arabic.
That part will place it, Lordship. Otherwise, Lordship, every department.
No, just place it. And what is this decision will also be applicable to drop teachers.
Lordship.
This decision of yours,
Lordship.
which is there on record,
That decision, they cannot engage any person.
even under the continuing venture stage employees,
Answer stage that cannot be after provincialization, Lordship. That particular college.
none of that.
Lordship.
People who were there in the venture stage,
Lordship.
not provincialized,
Lordship.
whether they will be allowed to continue or they will have to leave.
They are not.
But if you don't have the minimum
As-
requirement,
As because we have also that particular schedule is there. Also. In the 11 Act, there is a schedule. Also. Here schedule is not there. But as per if those is general courses, then three posts and major courses 4 posts. Also. And it depends upon the student teachers ratios.
heard Mr. D.P. Chali, Learned Counsel for the petition. Also heard Mr. K. Gogoi, Learned Standing Counsel, Higher Education Department, and Mr. A. Ganguly, Learned Counsel, appearing for the respondents number 3, 4, and 5. Also, the learned counsels for the respondents on the next date of listing shall place before this court the orders issued towards provincializing the services of eligible teachers in Hamidabad College under the provisions of the Act of 2011.
11
Under
and
the
17
Act
also.
of 2000, pura likhi divi.
11,
Also,
17 and
Ab-
18.
by
also.
Buddha, under 2000 teachers as well as non-teaching staff under the provisions of Act of 2011.
11, 17 and 18. Lordship.
No, this will be 11 only.
11.
This will be 11.
No, Lordship. Lordship.
Just get it. When? How long will it take?
Within a period of 2 weeks, we will file 2 weeks or 3 weeks, 3 weeks. Lordship.
Not 3 weeks more. Man, people are outside, so we give you 2 weeks.
2 weeks. Even Lordship, Hamidabad College, Sir has filed a petition regarding get 4 employees. Lordship. They all are Lordship now.
Inside.
Sir was the petition.
Oh, one was left out. That is why Sir is back again here.
Sir was the petition.
When Mr. Should I put it? 2 weeks?
Whatever Lordship comes.
Raise it to
Lordship, make it 3 weeks.
3 weeks. 3 weeks. The learned counsel for the respondent shall invariably file their affidavit in the matter on or before the next date of listing.
Lordship, will do. Oblige, Lordship.
Yeah. Heard Mr. H.K. Das, Learned Senior Counsel, assisted by Mr. N.K. Sharma, Learned Counsel for the petition. Also heard Ms. K. Fukan, Learned Standing Counsel, Learned CGC, appearing for the respondents number 1, 2, 3, 4. Also heard Mr. S. Chamaria, Learned Counsel, appearing for the respondent number 5 and 6. Have your seats. The petitioner in the present petition has prayed for the following reliefs. Page, etu bhalke mairi dis, etu kati thua ase, egur olop, put korate, 22, 18, annexure 22, annexure 18, annexure 19, annexure 20, eneka ase. Khali he uporot ulua nahi. এইটো খালি ভালকে টাইপ কৰাটা ভালকে দি দিবি A to A. As projected in the writ petition, comma, the petitioner who was the founder and proprietor of the College of Electronautical Engineering, comma, as projected in the writ petition, the petitioner is the founder and proprietor of the College of Aeronautical Engineering, comma, Borja, Gauhati, comma. The said college was established in the year 2009 and was offering the course in aircraft maintenance engineering, bracket AME, comma, bracket over, approved by the Director General of Civil Aviation, and also a course in the a course leading to the award of a degree of Bachelor of Science affiliated to the Gauhati University. It is further projected in the writ petition that the Director General of Civil Aviation, comma, on 8/6/2009, comma, under Civil Aviation Requirement, dash E, Part Roman 8 down, granted approval to the said college for offering the course of aircraft maintenance engineering. So, they said approval so granted was being extended from time to time. Thereafter, wide approval dated 25/6/2021, comma, the DGCA had upgraded the approval already granted to the petitioner college under CAR 147, now permitting the college to carry out to offer a course in aeronautical engineering with the specification made therein. So it is further projected by the petitioner that in terms of the norms coming into being, comma, the proprietor being required to nominate a person as the accountable manager of the college, comma, the petitioner had nominated himself as the accountable manager of the College of Aeronautical Engineering, and such nomination was approved by the DCGA authorities. It is then projected that the petitioner around in the year 2024, comma, on account of his poor health, was not in a position to operate the said college, more particularly the electronautical maintenance engineering course offered therein, and accordingly was in a lookout for a eligible person for being appointed as the accountable manager of the said college. Accordingly, it is projected that the petitioner had met the respondent number 6, who was the secretary of the respondent number 5 trust. So accordingly, the petitioner proceeded via a communication dated 28/2/2024 to appoint the respondent number 6 as the accountable manager of the said college, comma, subject to acceptance by the DCGA. Also, it is projected that on approach being made to the authorities of the DCGA for approval of the appointment of the respondent number 6 as the accountable manager. So we were accountable manager of the said college, comma, the authorities having required the petitioner to execute a deed of agreement in the matter, comma, the petitioner on 2/3/2024 proceeded to execute a deed of agreement with the respondent number 5 trust, comma, represented by the respondent number 6. The petitioner also executed a deed of agreement, a deed of declaration, declaring the appointment of the respondent number 6 as the accountable manager of the said college. So, the said documents being so submitted before the DCGA authorities, comma, the authorities of DCGA wide communication dated 1/4/2024 conveyed the acceptance of the respondent number 6 as the accountable manager of the said college. Also, thereafter, it is projected that the petitioner, on finding that the respondent number 6 was not operating the college in the manner required, and on learning that the respondent number 6, in connivance with the authorities of DGCA, was contemplating of shifting the campus of the said college from Borjar, Gauhati to Orissa, comma, the petitioner, via communication dated 29/4/2015, proceeded to remove the respondent number 6 from the post of accountable manager. So, the said aspect of the matter was also intimated to the authorities of the DGCA. So, the petitioner projects that after repeated approaches being made by the petitioner, comma, the authorities of the DGCA, comma, via a communication dated 24/7/2025, proceeded to convey the acceptance of the petitioner as the accountable manager of the said college. Also, it is projected that thereafter, the petitioner thereafter projects that on coming to learn from reliable sources that there was a move to cancel the acceptance of the petitioner as the accountable manager of the said school conveyed by the communication dated 24/7/2025, and also of shifting of the college from Gauhati, from Assam to Orissa, comma, the petitioner had approached this court by way of filing a writ petition being WPC number 4650/2025. The said writ petition is projected to have been moved on 13/8/2025, and this court had fixed the matter on 22/8/2025. However, on 13/8/2025, the DGCA authorities had renewed the license of the said college, approval of the said college in the name of the respondent number 5 trust. Further, the address of the respondent number 5 or respondent of the college was changed to that of the address of the respondent number 5 trust in Orissa, while approval dated 13/8/2025. So, accordingly, the said developments taking further, the DGCA authorities proceeded to accept the respondent number 6 as the accountable manager of the said college. The said developments taking place, the petitioner proceeded to withdraw the said writ petition being WPC number 4650/2025 with liberty. And accordingly, basing on the liberty granted by this court, the present writ petition has been instituted. Mr. H.K. Das, learned counsel for the petitioner, at the outset has submitted that the petitioner herein had nominated himself as the accountable manager when such a requirement was so introduced by the DGCA authorities for operation of the College of Aeronautical, College of Aeronautical Engineering. Also, it is submitted by the petitioner that on account of the poor health of the petitioner, he had nominated the respondent number 6 as the accountable manager, while a communication dated 28/2/2024. He also submits that prior to appointment of the respondent number 6 as the accountable manager, a discussion was already initiated, was underway with the respondent number 5 trust for operating the aircraft maintenance engineering part of the said College of Aeronautical Engineering. Accordingly, for the purpose of it is submitted that for the purpose of operating the aeronautical maintenance engineering part of the said college, the approval granted in this connection by the DGCA authorities came to be handed over to the respondent number 5 trust. And in this connection, the petitioner and the respondent number 5 trust had executed a deed of declaration / acknowledgement. It is submitted by Mr. Das that what was delegated by the petitioner was only the power to operate the college in question, more particularly the aeronautical maintenance engineering course offered therein and not the ownership of the college. Full stop. Mr. Das submits that it was only with the said intention that the respondent number 6, who was the secretary of the respondent number 5 trust, was appointed as the accountable manager of the said college. Mr. Das submits that an accountable manager can only be appointed oblique nominated by the proprietor of the institution wherein the course is being offered. So accordingly, he submits that the appointment of the respondent number 6 made by the petitioner was so made by him in his capacity as the proprietor of the College of Aeronautical Engineering. Next, Mr. Das submits that it being subsequently found that the respondent number 6 was not performing his duties and responsibilities as an accountable manager in terms of the CAR requirement, requirements, comma, the petitioner, via communication dated 29/4/2025, proceeded to remove him from the post of accountable manager. And the said aspect was also communicated to the DCGA authorities. It is projected by Mr. Das that subsequently the petitioner who had nominated himself as the accountable manager, comma, was accepted. Subsequently, Mr. Das submits that the nomination made by the petitioner of himself as the accountable manager, comma, after removal of the respondent number 6, comma, was accepted by the authorities of the DGCA. Via a communication dated 24/7/2025. Also, Mr. Das submits that it is in the above background that the orders impugned in the present petition issued by the authorities of the DGCA is to be so considered by this court. Mr. Das submits that a perusal of the impugned orders would go to reveal that the DGCA authorities, without there being any express communication made by the petitioner, expressly declaring therein that the ownership of the college was transferred in favor of the respondent number 5 trust, and the college and the situs of the college was also permitted to be changed from Gauhati from Assam to Orissa, comma, the respondent, the DGC authorities of the DGCA were not empowered to renew the license of the college in the name of the respondent number 5, and also to change the address of the college to that of the address of the respondent number 5 trust. Also, it is submitted that the DGCA authorities, having accepted the nomination of the made by the petitioner of himself as the accountable manager, after removal of the respondent number 6 as the accountable manager of the college, goes to reveal that the that the petitioner continued to be the proprietor in the continued in the records of the DGCA authorities to be the proprietor of the said college, and accordingly the petitioner being recognized as the proprietor of the said college, the DGCA authorities could not have proceeded to nominate the respondent number 6 as the accountable manager, basing on a nomination made in this connection by any other person oblique authority than the petitioner herein. Next, by referring to the agreements executed in the matter, on 2/3/2024, Mr. Das submits that therein the change of location of the said college was permissible to be so done basing on a request made by the accountable manager. He submits that the respondent number 6 having been removed from the post of accountable manager, the acceptance of such request by for change of the location of the college by the authorities of DGCA, was in clear excess of the jurisdiction vested in such authority such authorities in the matter. Accordingly, Mr. Das submits that all orders passed by the DGCA authorities after the removal of the respondent number 6, after the respondent number 6 was removed by the petitioner as the accountable manager of the college in question, stood vitiated, and the said orders would mandate an interference by this court. Mr. Das, by referring to the affidavit in reply filed in the matter, has submitted that in the agreement, in the deed of declaration of acknowledgement executed by the petitioner and the respondent number 5 trust, it was stipulated that the petitioner had received a sum of ₹7 lakh by way of a check bearing number 045007 dated 29/12/2023. Mr. Das, by referring to the bank account statements of the petitioner, as well as the certificates of his banker, has submitted that the said check was never deposited. The amount involved in the said check was never deposited in the account of the petitioner, and accordingly, the said agreement, deed of declaration of acknowledgement with regard to the handing over of the license of the license issued by the DGCA authorities for operating the college to the respondent number 5 society stood repudiated. He submits that the said agreement, in absence of the consideration thereof being transferred to the petitioner, would be of no consequence. By referring to the provisions of Section 25 of the Indian Contract Act, 1872, Mr. Das submits that the said agreement was rendered void. So, Mr. Das, in support of his submissions, has placed a reliance on the decisions of the Honorable Supreme Court in the case of Railpool Corporation versus Register of Trademarks, Mumbai and others reported in 1998. Yet, Return argument. And 98 8 SSC 1 and Harbhajan Vasan Lal Sahania and another versus Indian Oil Corporation and others reported in 2003 2 SSC 107 for the proposition that even on contractual disputes, if the action of the public authority assailed in a writ petition, is demonstrated to be illegal, arbitrary and discriminatory, this court would have the jurisdiction to examine the validity of the same as well as to interfere with such illegal orders. Mr. Das submits that although an alternative remedy of approaching the court of civil jurisdiction, competent court of civil jurisdiction is available to the petitioner, the petitioner in the present writ petition having demonstrated that the impugned orders were passed by the DCCA authorities without DCCA authorities in a most arbitrary and illegal manner, the said orders not being justified, not being permissible to be justified, this court in exercise of its jurisdiction under Article 226 of the Constitution of India can adjudicate upon the issue raised and also pass necessary directions thereon. Mr. Das submits that the plea of the petitioner being to the effect that the action of the respondent of the authorities of the DGCA in issuing the impugned orders not being found to be based on any material justifying the issuance of the said orders, only on the ground that there is a contractual dispute between the petitioner and the respondent number 5 and 6, respondent number 5, the present writ petition would not be mandated to be dismissed at the threshold itself. Mr. Das, with regard to his contention that the consideration involved in the agreement date of declaration of acknowledgement dated 2/3/2024 having not been paid to the petitioner, the said agreement was rendered void, has placed a reliance on the decision of the Honorable Supreme Court in the case of National Insurance Corporation Limited versus Seema Malhotra and others, reported in 2001 bracket 3, 2001 bracket of it, 3 SCC 151. Anything more left out? Where is Mr. Das?
What should be on legs in another
Or Thursday? Ms. K. Fukan, learned CGC, appearing for the respondent number 1 to 4, has submitted that the petitioner had applied for grant of approval in favor of the appointment made by him of the respondent number 6 as the accountable manager of the college in question. It is projected that along with such application, a deed of declaration executed by the petitioner on 2/3/2024 was also annexed. The ground assigned by the petitioner was that he was not in a position to run the institution on account of his health condition. Ms. Fukan further submits that in terms of the deed of declaration / acknowledgement, it is found that the petitioner, after the execution of the said deed, shall have no claim whatsoever on the business involved, and he shall not be liable / responsible for the affairs of the College of Aeronautical Engineering, more particularly with regard to the course of aeronautical KSL aiming course offered therein. Also, Ms. Fukan further submits that the petitioner in the said deed of acknowledgement, so and so, had admitted and acknowledged with regard to the sufficiency of the consideration price as well as the receipt thereof. Also, Ms. Fukan submits that in view of the above position, the authorities of the DGCA after having approved the nomination made by the petitioner of himself as the accountable manager, had proceeded, on being apprised of the actual background involved in the matter, including the execution of the deed of agreement / declaration, had proceeded to issue the impugned orders. She submits that the orders impugned by the orders issued by the DGCA authorities, impugned in the present writ petition by the petitioner, were all so issued basing on the declarations made by the petitioner himself. Also, accordingly, she submits that the impugned orders issued by the authorities of the DGCA, would not mandate an interference from this court. Mr. S. Chamaria, learned counsel appearing for the respondent number 5 and 6, has at the outset submitted that the present writ petition in view of the disputes raised therein based on the contract already entered into between the petitioner and the respondent number 5, comma, would not be maintainable before this court. Mr. Samaria, by referring to the deed of agreement dated 2/3/2024, submits that while the same, the control of the College of Aeronautical Engineering was transferred to the respondent number 5 trust, along with the approval for offering the AME course therein issued by the DGCA authorities. He submits that the said transfer was based on a consideration agreed and received by the petitioner in the matter. Mr. Chamoria, by referring to the provisions of clause 2 of the said agreement, submits that the petitioner therein had declared that he shall have no claim whatsoever with regard to the business of the said college with effect from the date of complete execution of the agreement, and he would not be in any way liable or responsible for the affairs of the College of Aeronautical Engineering, AME branch. Mr. Samaria further submits that in terms of clause 3 of the said agreement, the petitioner undertook to hand over all his powers and privileges with regard to the AME course offered in the college to the respondent number 5. Mr. Somaria, by referring to clause 5 of the said agreement, has submitted that the accountable manager appointed by the petitioner in pursuance to the said agreement, execution of the said agreement, was agreed. Mr. Samaria submits that it was agreed upon by and between the parties in the said agreement that the accountable manager appointed by the petitioner, who would be a personnel of the respondent number 5 trust, shall apply before the DGCA authorities for change of location of the college from Gauhati to Gunupur in Orissa. Also, Mr. Chamaria further submits that in the said agreement, it was also agreed that the petitioner would hand over the approval granted by the DGC authorities to the respondent number 5 trust, and such handover was undertaken to be irrevocable in future. By the petitioner hearing. Mr. Chomoria submits that the petitioner was paid the consideration amount as reflected in the said agreement, and accordingly the petitioner had not raised any grievance with regard to the same. Mr. Chamaria submits that it is only by way of filing a reply in the matter that the petitioner had raised a contention to the effect that the check issued for the consideration amount of rupees 7 lakhs was not credited to the account of the petitioner. He submits that the check issued had a validity period of 3 months, and thereafter it is not seen that the petitioner had invoked the provisions of the NI Act in the event the said check had bounced. Mr. Samaria submits that the respondent number 5 can demonstrate from records that the petitioner and the persons nominated by him were transferred money much more than that was so disclosed in the said agreement. He submits that in the event a civil proceeding is instituted in the matter by the petitioner, the respondent number 5 and 6 would be in a position to adduce evidence to counter the said contention raised by the learned counsel for the petitioner. Mr. Samaria has submitted that although the orders impugned in the present writ petition were so issued by authorities, by public authorities, the basis for issuing the said orders is the contractual agreements entered into between the petitioner and the respondent number 5. Accordingly, in the event the petitioner alleges that there was a violation of the contract entered into by him with the respondent number 5, and or wants to project the definite terms of the contract agreement in a different light, the same would be permissible to be so done before a competent court of civil jurisdiction by adducing due evidences thereon. He submits that the said agreements executed by the petitioner have not been repudiated till this very date. Not repudiated till this very date. In support of his submissions, the learned counsel for the petitioner has placed a reliance on the following decisions of the Honorable Supreme Court. Moyar A, B, C, D, should it? Page 7. I've heard the learned counsel for the parties and perused the materials available on record. The rival contentions of the parties to the proceeding on the factual matrix involved in the present petition has been considered. It is not disputed that the petitioner was the proprietor of the College of Aeronautical Engineering, and he subsequently had executed an agreement in the form of a deed of declaration / acknowledgement with the respondent number 5 trust, which was represented by the respondent number 6. The recital made in the said agreement would go to reveal that the petitioner had agreed to hand over the approval granted by the DGCA authorities on 25/6/2021 in respect of the aircraft maintenance engineering course to the respondent number 5, at an initial consideration of rupees 7 lakhs only. Foresaw. The deed of the terms and conditions of the said agreement. The relevant terms and conditions of the said agreement, comma, being the basis of the issues arising in the present petition, comma, is extracted herein below for ready reference. Apostrophe Mari, A to Mari Shunu, B, C, page 36. B, F, E, কিন্তু এইটো ABCD নামাৰিবি ইয়াৰ পৰা কোট কৰি যাবি গ্যাপ দিবি ডট দিবি যদি গ্যাপ আছে ডট দিবি তাৰপিছত নেক্সট মাৰিবি A perusal of the said terms and conditions would go to reveal that the petitioner, in lieu of rupees 7 lakhs, lieu of a consideration of rupees 7 lakhs, had handed over the approval oblique license for running the aircraft maintenance engineering course in the said college to the respondent number 5 herein. The said agreement further provides that in terms on the strength of the said agreement, comma, the respondent number 5 would create GIET gap U gap College of Aeronautical Engineering, and the petitioner shall have no claim whatsoever on the said business with effect from the execution of the said agreement. And further, that the petitioner shall be in no way liable oblique responsible for the affairs in connection with the College of Aeronautical Engineering, comma, AME branch. The said agreement also mandates also empowers the respondent number 5, respondent number 6 to apply to the DGCA authorities for change of location of the college from Gauhati to Gunupur in Orissa. Also, what is further most relevant is that in clause 9 of the said agreement, the petitioner had handed over the license approval granted by the DGCA to the respondent number 5 with a further stipulation that such handing over shall thereafter never be revoked oblique annulled and or made void. Also, a perusal of the said terms and conditions of the said agreement would go to reveal that the petitioner, in addition to handing over the approval to the respondent number 5, comma, had also transferred his proprietorship rights in the College of Aeronautical Engineering, at least to the effect of offering therein of the AME course. The transfer of license in view of the terms of the said agreement was to the respondent number 5 was permanent in nature. Also, it is seen that after the execution of the said agreement and the appointment of the respondent number 5 as the accountable manager of the said institution, the petitioner had not interfered with the activities of the said institution for a period of 1 year. It is after a period of 1 year since the date of execution of the said agreements that all of a sudden the petitioner had proceeded to cancel the nomination made by him in favor of the respondent number 5, the petitioner proceeded to remove the respondent number 5 from the post of accountable manager. This court, for the purpose of this court in the present proceedings, is only adjudicating the impugned orders passed by the authorities of the DGCA. For appreciating the contentions made by the authorities of the DGCA towards issuing the impugned orders, this court would observe that on the date when the petitioner had cancelled had removed the respondent number 6 as the accountable manager of the said college, the agreements executed by him on 2/3/2024 was not repudiated. The said agreement continued to remain in force, and accordingly, and the approval of the for offering the said course, AME course in the said college being already transferred to the respondent number 5, it is not understood as to how, without the said approval now being in the possession of the petitioner, he can proceed to again project himself as the proprietor of the said college. It is to be noted that in terms of the said agreement, the right to operate the said college was already vested with the respondent number 5. Right? So, accordingly, the intermittent appointment of the petitioner by the DGCA authorities as the accountable manager of the said college, is found by this court to have so occasioned the intermittent appointment of approval of the nomination made by the petitioner himself as the accountable manager, wide dash communication dated dash issued by the DGC authorities, is found by this court to have been so effected, basing on the factual matrix of the matter not being disclosed to the DGC authorities. The DGC authorities thereafter, on being apprised about the factual matrix operating, holding the field in the matter, including the agreements executed by the petitioner, had proceeded to issue the impugned orders. লেখা A to A. Para 10 ইয়াৰ পৰা A to A মাৰি দিম। তাৰপিছত B to B. Also, having noticed the contours of the power of this court in such matters, in adjudication of such matters, this court would now examine the orders passed by the DGCA authorities, but would examine the impugned orders passed by the DGCA authorities. This court, as noticed herein above, this court has already noticed herein above that the petitioner voluntarily had executed agreements with the respondent number 5 for a consideration, and while they said agreements, he had divested himself of the rights in the said operation of the said college, which he now seeks to reclaim by way of institution of the present writ petition. The petitioner in the said agreement had unilaterally undertaken that the approval of the DGCA authorities handed over to the respondent number 5 shall not be revoked or annulled. Also, the action on the part of the DGCA authorities in issuing the impugned orders is not found by this court to be a suo motu exercise carried out by it, divorced from the contractual matrix involved in the matter, more particularly the contract between the petitioner and the respondent number 6. This court finds that the steps taken by the DGCA authorities are corrective in nature, which have been so taken on the correct facts being placed before the said authority. The petitioner in the present writ petition has not demonstrated that the impugned orders passed by the petition, by the DGCA, by the authorities of the DGCA was so passed in violation of the act and the rules holding the field. Also, in view of the said conclusion reached by this court is of the considered view that the invocation by the petitioner of the writ jurisdiction is, in substance, an attempt to obtain, through a public law remedy, an outcome that the private law of contract and the doctrine of estoppel would would disallow. The petitioner in the agreement, having projected to have received the consideration involved, and basing on such consideration, having transferred his rights, including the approval for operating the said course in the college concerned, to the respondent number 5, cannot be permitted to now, without demonstrating the agreement to have not been performed by the respondent number 5, number 5, to assert rights which are inconsistent with the projections and undertakings made by him in the said agreement. The petitioner, the relief under Article 226 being a discretionary relief, comma, equitable in nature, comma, the same cannot be extended to a person who approaches this court, who does not approach this court with clean hands, and who tries to wriggle out of his contractual obligations and consequences by resorting to seeking remedies under the writ jurisdiction. This court has examined the decisions relied upon by the learned counsel for the parties and had factored the same while drawing the above noted conclusions in the matter. So, having drawn the said conclusions, comma, this court would now examine the contention raised by the learned counsel for the petitioner that the agreement executed by the petitioner was rendered void in view of the fact that the consideration thereon was not paid by the respondent number 5 to the petitioner herein. The said contention raised by the petitioner would not be permissible to be adjudicated by this court in a summary proceeding like that in the writ jurisdiction. Inasmuch as in the writ petition, the petitioner had not projected any such contention. Such contention came to be raised for the first time in the affidavit in reply filed in the matter by the petitioner to the affidavit in opposition filed by the respondent number 5 and 6. In the event the amount involved by way of a check was not received by the petitioner, comma, there was nothing preventing the petitioner to proceed to repudiate the contract, the agreement executed by him. It is found by this court that the said agreement still continues to remain in force, and the same has not been annulled by the petitioner. Also, further, the petitioner has not demonstrated that the validity of the check being only for a period of 3 months, comma, the check being issued on 29/12/2023, comma, as to why the check was as to why the same was why he had acknowledged the receipt of the consideration and also the sufficiency thereof. The petitioner, after the execution of the said agreement, for a period of around 1 year, is not found to have raised any objection in this connection, which further goes to 45, the contention raised by the learned counsel for the respondent number 5 and 6, that the consideration involved in the said agreement, as well as further payments as was agreed upon, were duly released to the petitioner and or persons nominated by him in this connection. So this court, as the matter stands today, this court would have to place a reliance on the conditions as set out in the said agreement. So, in the light of the said agreement, which is continuing to hold the field, the contentions raised by the petitioner in the before this court would not mandate a consideration. The petitioner in the event has to establish the contentions now raised before this court with regard to said agreement, he would have to institute appropriate proceedings before the court, competent court of civil jurisdiction, and therein demonstrate as to how the said agreement was rendered null and void in absence of a consideration being paid as agreed. Also, in view of the conclusions reached by this court, the claim made by the petitioner in the present petition, for the reasons assigned here in above, is held to be not maintainable, and accordingly the present petition stands dismissed. However, with liberty to the petitioner, if so advised, to seek appropriate remedy before the competent court of civil jurisdiction, in accordance with law. For the proper adjudication of the matter before the competent court of civil jurisdiction, this court clarifies that it had only examined the challenge made in the present petition to the orders passed by the DGCA authorities in the light of the agreement executed between the petitioner and the respondent number 6, and not on the merits of the said orders. Also, the said orders are left open to the petitioner to be contested on merits after establishing that the agreements involved were rendered null and void on the consideration thereon not being conveyed to the petitioner. Also, with the above disposed. Yes. Well. Very soon. It was a draft money, draft at my draft at my. It was a pilot.
Oh, authorized. Huh?
Ebru আছে নে? Yes.
My lord, that matter, my lord, regarding that rule, applicability of the rule, my lord. Lord, if we go by the rule, my lord, and my lord, I am helpless, my lord. I have to be ousted.
Mr. A.R. Via, Lord, counsel for the petition.
No, my lord, I have
Senior
not.
counsel for the petition
I have not
submits
finished
that.
my submission, my lord.
In the event the appropriate rule is applied.
Applied. That's the issue.
Yes.
Now, my lord, now, my lord, that's why, my lord, I am submitting, my lord. General principle, my lord, with my very limited understanding is the advertisement, my lord. My lord, this is a situation, my lord, wherein, my lord,
Yeah,
my lord.
this is the beauty of this Mandal selection, along with some other beauties available.
No, my lord.
The beauty is
My lord.
that this selection is based, as it was then,
My lord.
on the determination made by the deputy commissioner of the vacancies of Lat Mandal that would come up.
My lord.
Now, therein, there is already the demarcation made between general and reserve. So when he makes it in that line.
No, my lord, I am not on that, my lord. The power of the rule is there, my lord. Now, only, my lord, the principle which we generally follows in a recruitment or for a training.
Show me.
The
That beyond the rules.
No, no, my
If
lord.
the
Yes,
affidavit
yes, my lord.
advertisement does not specify, it's null and void. Show me.
No, 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 my lord, no, I am also not that also, my lord. The very conditions and the rule of the game, which has been, my lord, demonstrated in the advertisement, my lord, never says that the reserved category candidate should come up with an application annexing their certificate of the document which they are claiming reservation. Now, my lord, here is a case wherein, my lord, the petitioner says that we do have also the economically weaker section reserved category at that relevant period of time. Now, my lord, that opportunity, as we do not know that whether the reservation law is going to be followed or because they are, my lord, just simply following the advertisement, my lord. So that's why, my lord, the rule which has been demonstrated in the advertisement, my lord, has been later on basing, if we go by the, my lord, language of this, my lord, rule, if, my lord, just for a moment, my lord, I am sorry, my lord, traveling at this stage, rule 20, my lord. May I read, my lord? Rule 20 says, my lord, that for admission into the course, each course, the director will invite application from intending candidates, preferably by the middle of June each year, before the final selection is made for admission to the course. The director will obtain a statement from the each districts in regard to the following: the lots which are vacant, next 3 years, the date from which the vacancy arises and thereof, the lots with non-resident mandals or unqualified mandals, the number of survey pass persons in the locality waiting for appointment, and number 5, my lord, that the reserve vacancy and the backlog position regarding scheduled tribes, plain tribes, scheduled caste and other backward classes in the districts and subdivision, and in making the final selection, the director will pay due regard to the need of the districts. Now, my lord, whether the director, my lord, after this initial conclusion was there, my lord, whether this due regards, director will pay due regard to the need of the district. Whether this due regard in what manner he had extended.
You told me that there was no need for a due regard.
No, that is the
When
issue.
was
my
the
lord.
selection held?
My lord, it is on 2021, my lord. The advertisement last date was, my lord, 20/02/2020. And the, my lord, this select list which had been published.
Where is the select list?
Yes, my lord. Select list is at page 42, my lord. Date to the online.
Page?
My lord, in my
writ petition page 43, my lord, is of 29/9/2021, my lord. The signatures reflects the date, my lord. 20/09/2021,
So this is
my lord.
page 78.
No, my lord, in my writ petition, it is in page 43 and the.
Sorry, page 42 is the type copy,
My lord. Yes,
Huh?
yes, my lord.
right?
Yes, my
Now
lord.
you come to the remark column.
My lord, the.
They
writ
have
column-
duly taken care of the reservation there.
No, I am not on that, my lord, that the, as the SC/ST says, my lord, that the
Now you come
reservation-
to, what is the date? This is 21.
21.
Now you come to page 78, running page 78.
Affidavit, my lord.
Hmm.
My lord.
Now here,
Ma-
this is the advertisement for undergoing the so and so training
Yes.
by the
di-
deputy.
di-
Here, the complete breakup is given.
No, my lord, the breakup was given, my lord, but this says, my lord, the director will pay due regard to
once the breakup
need
is-
of the districts.
Once
need
the
of
breakup is given by the appointing authority,
My lord,
the training authority is the director.
my lord.
He has to apply. So at page 78, we find that the appointing authority has disclosed. And in page 42, we find that he has copy pasted that. What more is required?
No, my lord, at least the minutes or the reason that why, my lord, that due regard, that has not been, my lord.
Okay, done. Got it.
that
Next,
is-
next point.
Next point, my lord, is that regarding this rule, my lord. My lordship, actually, my lord, this is my first case dealing with these mandals, my lord. And I have never come up with this, my lord, this rule. Now, this rule, my lord, when we verified in the various websites or, my lord, other available portals, my lord, we do not find that this rule had been gazette notified. Now, my lord, whether
These
a
rules
rule.
are not notified.
No, my lord.
This is the training rules.
Yes, my lord.
Nothing like it, Lekha.
My lord,
We say no training. The training is also bad, illegal, bad.
the entire Assam training
Everything
go.
will go. If you say that, we are going. So you have no grievance.
No, my
We'll
lord,
we'll cancel all these election. That's all.
No, my lord, I am, my lord, with all respect, my lord, my lord, opinion.
We
expressed-
cannot apply that thing partially. If the rules are not
No.
proper, it goes.
Exactly, my lord. My lordship knows, my lord, the recent Supreme Court judgment has also said, my lord, that once if the rule is not notified in a proper manner, then, my lord, that cannot turn out to be a
What
law.
is the age of that rules?
My lord, the age of the rules is very, my lord, 1992, it is amended, my lord. I think it is prior to that also, my lord.
These are pre-independence rules.
Pre-independence rules, my lord. That's
So
why, my
this
lord.
is protected by Article 13.
No, my lord, I am not on that, my lord. The issue is that regarding this part, which came in the year 1992. Now, whether this has been gazette notified or not, my lord, at least my lord can have a clarification from the state, my lord, that when it had been notified, my lord. Because it is our specific contention which we have raised in our reply. My lord,
87, 88, 1887, 88.
No, that is there, my lord.
And
The
three
old-
other, this, I'll handle that. Don't worry. You make your submissions.
Now, my lord, if in our reply, my lord, we have also relied, yes, we have also relied, my lord, the division bench judgment in page 105. Just for a moment, my lord, I am referring to page 105, my lord. Paragraph 6, my lord.
105.
105 of our affidavit in reply, my lord.
Yes, yes. Sir.
Paragraph 6 is a perusal of the 1992 rules shows that the same has not been made on the basis of any statutory law oblique rule of the Constitution. In the case of Union of India versus Tulsiram Patel and others so and so, the apex court has held that the source of power must exist for its exercise. In the present case, there is nothing in the 1992 rule to show that the rule have been made on the basis of some source of power.
Yes, you're right.
My lord.
You're right. Okay.
So therefore, my lord, as the state is now relying on a rule which do not have that power, my lord.
So how is this training to be provided if these rules are not there?
No, my lord, training is not an recruitment or employment, my lord.
No. The
My lord.
training has to be, there has to be some basis.
No, my lord, I am not saying that.
How
there
did you
should-
apply for that training?
No.
First place.
Applying, my lord, that
No, how did you apply?
The principle which they have.
No,
my
no,
lord-
no.
Well-
In pursuance to which page you applied? Advertisement?
My lord, yes, my lord, the advertisement is at page number 34, my lord, if just for a moment, my lord, if
How
I,
have you, with the rules are not notified, this is also not there, this is also bad.
yes, my lord, that
So everything will go-
verification government has not.
Because the division bench has already said
My lord.
that rules have no application.
This is about a single bill.
Not a division.
Page number 10.
Be that as it, coordinate bench, it's binding on me.
Coordinate bench.
Page
my lord.
106.
It's binding on me, Mr. Hendik.
106.
Division bench is at page 107 below.
Okay. You mean to say this, this rules are not applicable? Okay.
No challenge. This rule has not been challenged.
No, he does not know about the
No,
rules.
no, my lord, this rule has never been, my lord, made.
I don't
applicable, my lord.
No, my lord.
No. What is that? That is no argument.
My lord,
If the
this,
rule is not there, it's not there.
so my lord, the,
Now you have a rule. From when?
2023.
2020. That is notified.
There is no notified. But if I already been, that was submitted.
2020.
deputy disseminate rule.
Subordinate service rules. Okay.
No, deputy, yeah.
Is there a repeal provision here?
About police, clearly mentioned.
Okay. Mr. Bhaiya, anything more?
No, my lord, the second limb of my, my lord, argument is that, my lord, a similar, my lord, case came to be considered before this honorable court, my lord. For that, my lord, the similar issues regarding that the change of the rule of the game and the applicability of the rule had also been considered, my lord.
Yes,
Just
yes,
for a
please give
moment.
me.
Yes, my lord, I am bringing my lordship's kind attention, my lord, to page 1, starts from page 99, my lord. There, to there. Page 99, my lord. My lord, may I read, my lord?
Well, if you can give me a minute, I'll finish it.
My lord, my lord. Same advertisement. sir. Date, full district. Full district. No, I think, my lord. Oh.
Yes.
Oh, my lord, the exactly in a similar footing,
Yes,
my lord, this order had also been assailed before the honorable division bench also, my lord. And the honorable division bench, my lord, at page 108, my lord, is actually, my lord, the interim order was put into challenge by the director, my lord. Wherein, my lord, the honorable division bench has prima facie opinion on this that it is not a normal selection where the reserved posts have to be filled by the members belonging to the community for which the seats are reserved, and in case there are no candidates available, the seat will be carried
In
forward
this,
to the next.
in this orders, in this two orders,
My lord.
the validity of the rules, applicability of the rules was not gone into in
my
both these cases.
But my lord, in the other one, it had been reiterated, which I have just relied on, my lord.
That rules are not notified.
Not notified, my lord. So now, my lord, yes, my lord, no, my lord, I cannot go beyond the records which are not here, my
No,
lord.
no.
Exactly, my lord.
You have hit on the nail on the head.
My lord.
If the rules are not there,
Exactly, my lord.
everything falls to.
Everything. That's my limited submission,
Look,
my lord. So, my lord,
Mr. A.K. A.R. Bhiya, learned counsel for the petitioner. So, Mr. Bhiya, just taking down, huh?
my lord.
Also heard Mr. J.K. Goswami, learned counsel for the learned standing counsel, learned additional senior government advocate appearing for the respondents number so and that's three loads. Three. And Mr. J. Handy, learned standing counsel, revenue and disaster management department appearing for the respondents number so and so.
1, 2, and 4.
1, 2, and 4. Bale ekuna khali Bhiya sahab argument ke likhi lo. Mr. A.R. Bhiya, learned senior counsel appearing for the petitioner by reiterating the facts noticed herein above, has submitted that the denial to the petitioners of a nomination for undergoing the selection process, although in the undergoing the nomination for undergoing the training, although they were selected and within the merit position for such nomination, had so occasion on account of the fact that the petitioners, that the respondents had applied the provisions of reservation to the recruitment so made to the for nominating candidates from the select list for undergoing the training in question. Mr. Bhuya has submitted that the petitioners had applied for undergoing the RCC training basing on an advertisement dated 24/12/2020 issued by the Deputy Commissioner.
Director of Land Records.
Where is that advertisement?
My lord, it is at page 34.
Basing on an advertisement dated
Lord, this is dated 27/1/2020.
issued by the Director of Land Records and Survey. Mr. Bhuya submits that a perusal of the said advertisement would go to reveal that therein no reservation, no provision for selection of candidates for undergoing the training in question by applying the provisions of reservation was so made. Mr. Bhuya accordingly submits that the application of the provisions of reservation after the selection process was complete, amounts to changing of the rules of the game after the game had begun. Mr. Bhuya has further on the said subject submitted. Mr. Bhuya, with regard to the provision not being made for reservation in the advertisement, has further submitted that the same had also prevented persons having a reserve status from submitting their application by also annexing documents with regard to documents like their caste certificates. Also, Mr. Bhuya submits that the respondents have relied upon the provisions of the Assam Survey Settlement Training Center Rules 1992 to justify the application of the provisions of reservation in the selection involved. Mr. Bhuya submits that the said rules are not statutory in nature and is also not found to have been notified in the Gazette. Accordingly, he submits that the said rules would have got no legal validity and cannot be applied and cannot be made the basis for denial of opportunity to the petitioners for undergoing the said training when they had scored more marks than the persons actually
Fine,
deputed
select.
for undergoing the training. Also, Mr. Bhuya, in support of his submissions, has relied upon the decisions of this honorable court in the case of Dipankar Majumdar and other versus State of Assam and others, order dated 23/1/2024 in WPC number 5937/2021, comma, comma, the order dated where is my lord justice? That one, no? That
My
one.
My lord, 6/12.
One is.
6/12.
This two orders only, the ones you have annexed, that much only you are relying?
My lord, 104, page number 6/12/2021, my lord.
Huh.
And
That is an interim order,
that is an interim, and final one is, my lord, that.
page
my-
99.
Yes, my lord justice has Suman Shyam,
One, that,
Fine.
and the division bench.
ultimately, yes, my lord.
This two only,
Yes, yes, my lord.
and the order dated 31/3/2022, passed by a division bench of this court in writ appeal number 68/2022. In the above premises, Mr. Bhuya submits that the respondents submits that this court would be pleased to direct the respondents to permit the petitioner to undergo the said training program. I'll hear you on the next day. Then pass. Just others I'll forget.
Only that lordship the order which was passed in the application number 5966 lordship. There is advertisement to ask the post final vacancy was 22. Out of 22, the 16 was lordship selected, and 2 are reserved for the ST or.
Okay, Mr. We'll take it just because I'll forget it. Otherwise, that's why I've taken it.
Yes, my lord.
Now you know his challenge. So kindly make your submissions on that line. Rules. Because may look a very thing, but it's going to the root of the matter. Your entire selection will go.
My lord.
You think over it, huh? Heard the Parliament Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again. How long? The week next, not the next week, the week thereafter. Because next week we only have 2 working days.
11th of September, my lord. Possible, my lord.
No, 10th.
My lord.
10th, 10/9. We'll finish it on that.
My lord.
And if you get something more, just.
Yes, yes, my lord. I will try to assist more, my lord, regarding this subject.
Yes. Padahin. Papa, we don't connect you. This bad habit of forgetting, nah, that's the problem. That's why I took it down. The next day again, I'll have to ask you what it is. Yes. None appears for the petitioner on call. For the ends of justice, registry to list this matter again after a week on a date to be fixed by. The matter be not treated as parted and tied up matters with this court any further. Yes, Mr. Goswami. That matter.
Videography.
Yes, videography. Yes. You have seen the videography.
I have.
Then what do you get?
I don't get to see the faces of the inquiring officer and the presenting officer. I see only, and I think it was a clandestine affair, my lord, this video. And
Okay, on merits. Yeah.
on merits, my lord. He was given an opportunity by whom I do not know, because I don't see the faces of the persons, my lord, asking questions. That is why, my lord, I wanted that your lordship should once go through it.
I'll take your words. If there is dispute, we'll forget. That's all.
But one thing is sure, my lord, there
Where
was
is the statement of the witness that who had appeared?
statement of the witness of Bhaskar Dutta, my lord.
Where is that?
Bhaskar Dutta, his evidence is not copy is not given to us, my lord.
No, it's there.
Huh?
It's
Is it
there.
witness affidavit or?
It is there.
He has only two grounds.
Oh no, forget their grounds. Where is the original of the statement of the Bhaskar Jyoti Dutta?
But this is 116.
No, I want the original.
Original.
We had required Ms. Bora to keep everything ready. Why is the records not ready?
Records mean lordship, these are all digital lordship. These are.
No, where is this digital? This cannot be digital.
Earlier
This has
occasion,
to be originally signed. It cannot be digitally signed. Was it taken online?
It's online as well.
no.
Photocopy only.
Cannot be. There has to be original. Order sheet.
The original has not been furnished, lordship. These are all, I mean,
Mr.
computerized copies.
Mr. We have to have the original to show that the signature of the petitioner was taken there. That will be the proof that he was there. And what is written there is accepted.
Even if it is not.
No,
there,
we'll not
lordship,
accept
lordship,
anything.
that is why the video has been annexed, lordship.
Video is nothing, mister.
Lordship.
We want the signature of
Lordship,
this
this
person.
video has been annexed with a section 63 certificate, lordship.
Okay, we'll draw our conclusions on that.
And most importantly, lordship, I'm repeating, lordship, that is not his
You
grievance.
show me the signature of this man. Where is the order sheet? In the order sheet, where is the signature of the witness? Where are those minimum basic procedures?
Lordship, first thing, lordship will say he denied that in the hearing of that particular day, he was not communicated.
Forget his denial.
Lordship, that is there.
Forget, can you get me those copies or you can't get? That much only you tell me.
Lordship, whatever I have been conveyed, lordship, probably his signature was not there on that particular day.
Where is the order sheet of that day? And these are not the first time I'm asking. And why this the Xerox business is resorted to? Where are the originals? Originals kept in safe custody somewhere. FD. Why photocopy? Who is the authority holding this post? This. Mr. Naik, get the original. This cannot be your e-file.
Probably these are e-file, lordship.
How can it be, Mr.
Probably that is why everything.
Fine, videograph is something. Where is, can it be?
I am going to ask the authority once again.
Mr. Naik, was he in a remote location?
No, he was present, lordship.
The inquiry officer was present there?
Yes.
These are statements made therein. It cannot be made in the, then it should be signed digitally, not hand. On the prayer of Mr. A.P.P. Naik, registry to list this matter again. Monday ki tarah se? No. 21, ho jabo na? Na lagi, kundi na di pare. 7/9, on which day the records in original pertaining to the inquiry held against the petitioner shall be produced by the Standing Council Transport Department. Then you make your submissions.
He was not even asked that videography was going to be used. Even that was also not there. It was some clandestinely used device. Put it possibly, my lord, from the
What I'm
angle.
submitting,
It could be seen, my lord.
Lordship must
One
have
of them
seen his
can use it.
representation.
Was it
I
his
have not
objection?
seen anything. Get me the original records, then I will.
Original will be there, Lordship.
Yes.
If it is there, it will be definitely placed, Lordship. But only thing,
Yeah,
Lordship,
that will feel.
it was not the objection raised by the petitioner, Lordship, when he submitted his representation against the inquiry report.
We'll consider that. We'll consider his conduct, no
I
problem.
mean, it is the creation of my friend, Lordship.
That is the duty of Mr. Goswami. Now you have to, you have to.
Now, my lord, the second inquiry will start with me as the delinquent, my lord, sitting in front, video camera, in pocket.
We are having it here only. You're on camera. Don't worry. Yes.
Much obliged.
Hey, Savi. You pull them.
Lordship has fixed it for passing the order.
Ah.
Probably.
Hmm.
Because we have already made a statement regarding that inspection part of Hamak. Hamak police.
Also, on the last occasion, I raised the point with regard to the fact that relevant documents were not furnished, and even repeatedly we have submitted various representations before the authorities. With regard to the photographs.
Today not possible.
Lordship will fix the date.
I've passed enough today. Today I can't anymore.
Yes, sir.
Not a
I'm
council
having some
for the
difficulty.
parties. Hearing remains inconclusive. Registry to listless matter. Date 30th. 8, 9.
8, Lordship, if it is possible. 8 and.
We are only passing the order. Your juniors can be here. No problem.
Certain points I will raise before this vote. Certain points I will add, Lordship.
Then you make it now only. Daily there cannot be hearing, na? Yes.
Here in this case, Lordship, the first of all, the documents which were placed before the inquiry committee, at that point of time when the photographs were annexed, these photographs.
Enquiry committee means which guy? Your enquiry, the departmental enquiry.
Departmental inquiry. At that point of time when the show cause notice was issued, and prior to that, Lordship, when we submitted the inquiry with regard to the fact that whether the concerned institute fulfills the required criteria under the this Pharmacy Council of India. So accordingly, we have submitted all the relevant documents and all photographs were annexed. So
What is your point?
Yes. So basing on that point, Lordship, when the allegations were made with regard to the fact that the report was submitted on this 29/7/2018, which was false and sought to unduly favor the private institution. So immediately thereafter, several representation I have annexed all those documents, Lordship, relevant documents. Lordship, kindly see annexure 9, page number 64. Here.
What did you want in those that your.
Exactly, Lordship. The photographs which were annexed at that point of time, these photographs were not retained by the petitioner during the relevant period of time, since these photographs are in the custody of the authorities. So these documents are to be furnished so that necessary defense can be taken. And even thereafter, Lordship, when we had submitted the representation before the special secretary, various documents I have annexed, annexure 9, annexure 10. If your Lordship kindly peruse this page number 67.
Okay, come.
Page number
to
67.
Come to the page 35 is your document.
Yes.
That is a submission.
35 is the document. Starting.
Now,
Yes.
now documents and photocopies enclosed.
Yes, that is the thing.
Who has written this?
The photocopies was mentioned.
Who wrote this? Star.
This one by the 3 persons, Lordship.
Where? Where is the signature after this? This is just written afterwards. The things should be there. How can this form a part of that? How do you form it a part of that? There is no signature below this. You have all concluded here. Top. How do you?
It has been concluded, but the fact is that
this document.
no, it's a part.
You have the original of
it's
this.
It's a part of the original record, Lordship.
This page 35. Was this prescription documents and photocopies enclosed there?
It will be there in the record here.
This
Photocopies, my lord, we have stated in affidavit, it is
No,
not.
that's what he says. We'll finish it up now only. And that is suppression. That will be another case now. 29/7/2019, submission of the first report.
It has been mentioned.
Mentioned. So where happened? What happened? Where are those documents?
But my lord, it may be there in this particular page, it has been mentioned, my lord. It's not that, my lord, any enclosure is there. We have stated in affidavit, my lord, there is no photograph.
So in the affidavit, they have stated, lordship. At that point
But
of
how
time,
do you, we photocopies enclosed? Oh, documents and photocopies enclosed.
Yes.
Not
No, lordship.
photographs.
Exactly, lordship. That has been
Ah.
subsequently, when the application was submitted before the concerned authority,
No.
it was mentioned.
Pick.
Lordship, kindly see page number 70. Lordship, kindly see, have a look at the page number 73. It has
No,
been
no,
clarified. Be it mentioned
No,
there
we
in the
will
inspection.
clarify it with some subsequent document. We'll clarify it from the original document.
No, Lordship, kindly see my representation.
Mr. Chaudhary, photocopy is pictures.
Lordship, kindly.
Pictures, you tell me yes, I will see. If no, I'll not see.
That was the justification of mentioning that photocopy. The wrong that was inadvertent mistake was there.
Oh, you.
That has been explained in page number
Mr.
73.
Chaudhary,
Lordship, kindly have a look at the page
Mr.
number
Chaudhary,
73.
whatever goes against your clients, that is inadvertent mistake.
Lordship,
They made a report that is inadvertent mistake.
I'm not on that, Lordship. When
You
the
be on
representation was submitted.
Okay, we have heard you enough.
No, when the representation was submitted to the
Lekha,
Deputy Secretary.
heard the London Council for the parties at length. Registry to list this matter Kundinaze of Dhaka, Delhi, 9/9/2026 for delivery of order.
Lordship, kindly mark page number 73.
Oh.
There I have clarified.
I know.
The petitioner has clarified that wrongly it was mentioned as photocopy.
Mister, who are you? What is your status? What is your status? Who are you? What is your status? That also we'll have to know. You are not a grade 4 employee. You are not a unread man. You are a very cream of the society. Do you expect that you will make that mistake? Never.
But the thing
And
is
a
that
doctor will know what a photocopy is and what a picture is.
but there was no response with regard to that particular communication.
I had not applied my mind last date to that.
Yes.
Now I have applied. So
I will submit two judgments on that particular date.
we will not accept any further argument. We have put it for delivery of orders.
Then today I will submit those. Yes.
Mr. Keep the record ready on that.
Lordship.
Don't give me, keep it ready.
9th of September.
You need not be here. We'll pass the order.
I'll be there, Lord.
If you are here to fine, no problem.
Any day, not today, Lordship.
As agreed to by the London Council for the parties when?
9,
Nine.
11, your lordship, 11.
11/9/2026.
They play.
Your lordship,
Yes.
I'm praying just 1 week time, lordship, to obtain the instruction. My lord, it goes on and on and on like that, my lord. Last date, if your lordship remembers, my lord, I had placed the decision of.
Yes. Where is Mr. Kaushik?
He's out.
Why the instructions have not come?
He's out of station, lordship.
Oh, we saw him little bit before here.
And he went out for return.
After coming to court, he went out station.
Yes, lordship.
Who is to give you these instructions?
Director, lordship.
Director of what?
Director of elementary education, lordship.
Elementary education.
Lordship.
Okay, did you communicate this order to the director?
Yes, lordship.
No response.
They're seeking 1 week
Let
time,
the
lordship.
director come.
1 week time, they're seeking 1 week time, lordship.
1 week time.
Lordship.
Okay. On the prayer of the London Council for the respondents, registry to list this matter again on 7/9/2026.
7 minutes, I'll be out of station. Let
And-
it be after 12 minutes.
12, after 12. Okay. 14/9/2026. 14 is Teachers' Day, no problem.
No problem.
Children's Day. No, Teachers' Day, not Children's Day.
Teachers' Day,
It's
5th
Teachers'
September.
Day.
14th November is children's day.
Oh,
5th
14
September.
November. 5th nahi hai? Oh,
5th September is.
I also forgot. Yes, Mr. Nath, sorry, you had to wait.
No,
till
it's all
late.
right. I'm just thinking other way.
Hmm.
After seeing your lordships this morning, my lord, I'm just thinking whether shall I not put tax on your lordship today? Those teachers, around 25 years now, they are serving in that post. There are similar teachers, 106 have been regularized. But these teachers, my lord.
Yes, Mr. Soma.
Lordship, the advertisement we have published
Hmm.
is on the basis of a notification dated 28th November 2023, which is in my affidavit, Lordship.
What happened to that advertisement?
That has been, that has been stayed, Lordship, and
Stay by this court
yes, Lordship.
in this proceeding.
Yes, Lordship.
Okay, how do you think you will be now entertaining their plea?
Lordship, we can't
You
because
can't.
the qualification needed to get regulation or to be a teacher has been given in the schedule.
Yes, which schedule?
Lordship, in that page number. In my affidavit, Lordship, there is a notification.
What is the qualification of the petitioners?
Petitioner does not, that means, Lordship, now they have to, they have to get a TET examination and all that,
Oh,
Lordship.
that is something. Do they have the basic qualification?
They are just, as per my instruction, they are just degree holders, Lordship. And
Degree? Oh, board, it's too much. Highly qualified.
but Lordship,
Primary school?
yes,
Highly qualified.
but
Yes, highly qualified.
but they don't have.
Only
TET and
they
all
don't
this.
have TET. They'll appear.
My lord,
Lordship, we can't.
actually,
That direction
my
has to be
submission
given
is
to the
basically nothing to do with the advertisement.
Huh?
Nothing to do with the advertisement.
Huh.
We are appointed in 2001 to
Ah.
those days we are appointed.
Hmm.
Similarly, absolutely similar qualifications and appointment, same terms and conditions. 106 teachers I have given the example here. All of them have been regularized
By the council.
by council. What has prompted
That
them,
was
my lord?
before
Nothing. Forget about this
2023.
advertisement, my
Ah,
lord.
that was before?
2023, Lordship.
And why did they left out?
That's what. Nothing to do with the
They-
advertisement.
Income tax case, that similarly situated person left out from the purview of regularization, they'll also be brought in. Get me that decision, Supreme Court. Mr. Gogoi, what was that decision? Similarly situated persons left out from the purview of regularization, then they'll also have to be given that income tax or central excise. What was that? I'll get it.
My lord, my lord. That is the only issue in this case, my lord.
Yeah, passing.
In 25 years running now, we are working, my lord.
Too much.
But
Those persons who appointed them, they are also not in the world.
And I just wanted one answer from them, my lord. On what basis? What's the policy? Those 106, to my knowledge, there may be more.
2 weeks back, it was delivered, recently delivered. sir.
No, it's all case.
No, it's one of the cases, similar case.
There. You just give it.
That's what was my only submission, my lord. What was the policy? What is the criteria? There's all those people there.
Learn a counsel for the parties at some length. Hearing remains inconclusive. Date today. 10 minutes. So, Mr. Soma, you can't. So, we'll have to do something. Done.
Published.
Aru asini. No, hearing. Pada hearing.
Published.
Yes, Mr. Bhattakur.
Same day,
This is your regarding receipt of promotional benefit, whether it will be from the date of order or from the date of eligibility.
They were initially what? Provincialized.
That's provincialized, they are in provincialized polytechnics, your lord.
That CS promotion part was, we'll address.
Cash
Cash,
promotion
yes.
only.
We will
Whether from the
address.
date of eligibility or from the date when it was actual order was passed, your lords. That's the issue, your lords. And as per AICTE guideline, your lordship, it is from the date of eligibility.
These are covered by technical.
Lordship,
But it's just
lord.
it's a selection post.
No, your
It's
lord.
a selection post.
Yes, lord, DPC is there, your lordship.
There are three conditions here.
Lordship,
3 dates would be permitted.
lordship,
One is the date of eligibility.
lordship.
That you have all qualification on this day, you complete 4 years, you will be considered. Second one date is, you completed 4 years, you did not have the qualification, maybe the undergoing training or something, you did not have. Say that you got it on a particular date 2 years later.
Lords,
Now it will be, that would be the date for
Lordship.
consideration. Third is the date when the DPC made your recommendation. Now, if we see it in light of promotion,
Lords.
it would be the date when the DPC makes the recommendation. Cannot be any other date.
Lordship, but your Lordship, the AICT, your Lordship, is very clear. From the date of.
Where
eligibility,
do I get it?
That your Lordship will find.
There was one decision. Not annexed.
No, I have given your Lordship. In fact, your Lordship, under 2018 guideline, they have issued your Lordship. That was the procedure, your Lordship. And our cases were processed under that guideline. Suddenly, when order is passed, your Lordship, they amended the 2018 guideline in 2024 and benefit was given from the date of issuance of the order.
Now, in your case, is it a case that you had the qualification,
Yes.
but they did not promote it in
Yes,
4
sir.
years?
Yes, sir. That's the case, sir. And
So it will be from the date of eligibility.
Lord, sir.
I will address it, Lord, sir. At this point, I will address it.
30. For the parties, as agreed to by the Learned Council for the parties, the registry to list this matter again for admission hearing on
Lord, sir.
11/9.
Deeply.
Hey, 11/9, Kukurbar, nalage. 10/9.
Lord, deeply.
Voted. Yeah. No, there is a delivery of order left. Oh, it's 4:30. There I'm a bit of a delay.
Any day, Lord, sir.
Not
They-
disclosed.
they will-
Mr. Islam,
they took a square over.
I'm disposing it off. From that day, you will be given
From
subject,
1/2021.
1/1/2020.
Bless.
But yeah. Yes, any urgency?
My lord, as per your comment.
In my comment. Do you someone to show to Baki kita? Time. Any urgent matter?
Apologies.
I'm sorry, the old matters took time today.
This is not exactly urgent, but then some prayer was made for payment of salary for a teacher.
When I give a date, convenient date, at a date given.
No, today was fixed for filing of affidavit from them. There is no response.
The item number?
Item number 28.
My lord, I am agreeing, my lord, I need some little accommodation.
Tom, file do.
Here, my lord, petitioner accommodated in the year, my lord, 2021, my lord. She has completed basic training in the year 2003. My lord, I need some time to bring it back.
No issue, but we had granted you time till 14/8.
True, my lord.
So now I have to change it. How can I? I don't have power. My own order I can't touch. That is the judicial prudence. So how much cost? And who is to? The director? Elementary, secondary,
Elementary.
elementary. How much? Choose yours. 5,000 to 5 lakhs, whatever you want. You recommend, I'll impose.
I'm paying some accommodation. Monday, my lord.
This casualness we are not accepting.
True, my lord, that is.
I'm hearing them and I'm disposing it. We are giving them full benefit from the date, and we will hold that you failed to file the affidavit. And that is why we are passing this out. And the government can recover from whoever is the defaulting officer. registered to, as prayed for by the Learned Council for the, this court had required the respondents to file an affidavit in the matter on or before 14/8/2026. The said order was passed on 22/7/2026. The matter was directed to be listed today for consideration. It is seen that the said affidavit has not been filed, and today, again, a prayer for adjournment is made for the purpose of filing the said affidavit. Prayer is rejected. The matter will now proceed without the affidavit of the respondents being filed. Who's up? Registry to list this matter again on Thursday next.
Milord, item number 37, 2019 hearing matter, Milord. Lordship, regarding but
yes,
any date in the September month, Milord.
Any date, September, as agreed to by the Learned Council, date 30. Yes.
Obliged.
So item number 45, my lord. Date may fix, my lord. Any date, my lord.
She'll give the dates, don't worry.
Most of.
She'll give the date diba. Jot diba as agreed to by the Learned Council.
Lordship, item 30. It may be fixed and
Item
30.
30.
30.
Date diba. Date diba. She'll give the dates, please do. Every interim order is there, just tell her she'll incur. Yes, madam.
Item number 33, I'm praying that it may be fixed next week, my lord.
Oh. Any interim order here?
Yes,
Yes.
my lord. There's a-
We have also filed an IA
What is
for.
the issue?
My lord, actually,
admission.
the student, the minor petitioner was seeking admission at KVS system.
That
Yes, my
case,
lord.
yes.
Non-compliance, so that I'm.
You have filed there was an interim direction.
Yes.
Yes, my lord.
And
We
that
have
was not,
also filed an
that
IA
has not
No, my
been
lord, it hasn't
implemented.
been.
Why?
My lords, because we also have no vacancy in the said class.
My lord, part,
We have also filed an IA for vacancy.
This order was passed in your presence?
Yes, my lords.
Then you had instructions on that day?
No, my lords.
I
We-
filed today.
My lords, I'm appearing on behalf of MS Rakhi Chaudhary. She's not available today, my lords.
So you wanted the IA to be taken up today?
Yes, my lords, I had attempted to
No,
call
make
for
a
it in
submission,
the
please.
morning.
Where is the interim order?
my lord, just 1 moment, my lord. My lord, annexure 1, my lord, page number 14, my lord.
So what is your case?
My lord,
No, forget your case. What is your case for vacation?
My lord, the IA is not on record yet, my lords. We filed it yesterday. I tried to make a mention for
Okay,
it.
we are calling for it. You make your submissions. A boy's life is involved.
Yes, my lord.
No, you make your submissions. We'll call for it. You have a copy of that.
Yes, we have.
You can give me a copy. We'll see.
My lords, if it maybe fixed next week.
You wanted it today.
Yes,
You had
my
pressed in
lords.
the morning for today.
Yes, but
You're hearing it today.
my senior is not there today, my lords.
But you wanted the matter to be taken up today.
My lords, actually, since my lord had opined that.
Oh, because of that.
Yes, yes, my lord.
Okay. Monday.
My lords,
Interim order passed earlier to continue.
my lords, on Wednesday, my lords.
Monday.
My lords, one short accommodation, my lords.
You file a contempt.
my lord, actually, that is a problem, my lord. I talked to the petitioner's father and he doesn't want me to file a contempt this thing because he'd be going there, my lord. His sister is already
Today is
studying in the
29.
KVS, my lord.
Today is 29. 27. On 9/9/2026.
Obliged.
Obliged, my lord.
Laura to leave over the house. 2/9/2026. Along with the interlocutory application stated to have been filed by the respondent number
224, my lord.
224.
Lordship, I beg to mention for item number 31, date may be fixed.
34.
30.
Date.
30.
She'll give the date, don't worry. Date kita di ba interim jot ase code level info. Etu hey বৰঠাকুৰ কি বলে